hospital.
Hmm?
The proposal for the second TB hospital came later, and this settlement order was passed prior to the proposal undertaken by the government for the second TB hospital.
And when were the notices issued? Let's see the notice. Huh?
10, 11.
Page.
Page lordship 35. In all the cases.
What is this order enclosed?
Order lordship, that was earlier order lordship passed by the
For what? What order is it?
it's in regard to
New order.
11 repeat transfer. Against the
No, what did you challenge out here?
here also the lordship notice was issued.
And what have you done, madam, in this matter?
Lordship, regarding this writ petition 292 of 2020, Your Lordship, this matter was also directed that specific representation application shall be made by the petitioners within 1 month. Your Lordship. And thereafter, Lordship, the settlement and even if any order of settlement and allotment is made, the petitioners would be provided with allotted plots of land. And in the event also, they would still be liable to be evicted from the encroached land, unless the land under their occupation is itself allotted, settled with them at the discretion of the authority.
Where is that order? Eviction notice? This one,
Eviction notice 35.
regarding encroachment. Oh, it happened recently.
Earlier also there was an
There was
we
another
approached this honorable
enforcement,
court.
there was another notice, Your Lordship, which was challenged in this writ petition, WPC 290.
Then,
Thereafter, Lordship, there is a pending PIL suo moto before the Honorable Division Bench of this High Court.
that I have seen.
On 31st of March 2021, there was an order passed by the Honorable Division Bench to the respondent authorities to, as per the law, if there is encroachment, Your Lordship, those encroachers may be evicted under the due process of law. Thereafter, this notice was
What is due process?
if they are found encroached,
Mhm.
because this particular plot of land has been allotted to the TB hospital. So that PIL suo moto was regarding the government land which were allotted to the government and institutions. The TB hospital is a government institution. And there are several other government institutions also within this dark number, and the plots adjacent to this particular dark number. Thereafter, the deputy commissioner and the other respondent authorities, they should be eviction notice. And thereafter, on receipt of this notice, the individual.
So all these notices which have been issued, which you have assailed by various writ petitions, are all 10/11/2022,
Yes, yes.
same date
Yes, sir.
to all the petitioners.
All the-
And how many petitioners have this settlement?
Only two.
Two.
Which one?
They are not
Shell
before this
Devi and
honorable court.
Sunil
Huh?
Raja.
Now they are not before this honorable.
These two people are not
No,
there.
no.
Sunil Razak and all.
Not
Sunil
in
Raja
this-
is there.
Where is he?
His number. This is not
Sunil-
listed today.
Sunil
Lordship.
Raja, yesterday their case was listed, Your Lordship, for another court.
WPC 7258.
Where is it? The matter is not here.
No.
Yesterday it was
It
listed,
was
Your
listed
Lordship,
before
before Honorable Justice Manish Chaudhary sir spoke.
Sunil Razak.
Yes.
And the other
Shell
one.
Devi.
Yeah, other
Shell
two,
Devi.
Huh?
and other two, Arun Kumar Singh and Shell Devi. Other two
They have also been given the settlement.
settlement order, they have received alert, but they have not deposited their premium.
They have not deposited. Only deposition only
Oh.
Sunil Rajat has made. Your
Only Sunil Razak.
Yes.
And those matters are not before this court.
Lordship. No, Your
Yesterday, these three matters.
So that only one petition I thought of allowing, that is also gone.
No, we Because due to paucity of time did not reach lordship yesterday, or otherwise we would have mentioned for listing it before this, for this thing.
I could have allowed at least one writ petition out of the many. Now, how much time?
Your lordship, yesterday, item number
49.
49 and 50 before court number
What happened there?
13, your lordship, the matter did not reach your lordship
Very well.
because of paucity of time.
Yes.
But only one person has deposited, Mr. Sunil Raju.
We are not concerned with that.
Yes.
This court is not.
Yes.
This court, all the people have not been, although they have applied for settlement, have not been granted the settlement.
yes.
Or there is no order of settlement.
Yes, sir.
You got the judgment?
Yes, Lord.
Yes.
Yeah, basically it's 16 that the Mozadar has no power to collect revenue, Lord.
No.
No.
Not only that, it says something more than that. But one thing is there.
Sure.
Why I wanted to show you this judgment. Look here, if you read it, kindly come to paragraph number . Yes, let us read paragraph number 4 onwards.
4.
Yes, read it.
Rule 16 of the rule framed under the regulation prescribes that these shall be issued on written application only, and no person shall enter into possession of wasteland in any area until a lease has been issued to him, or otherwise a written permission by the deputy commissioner has been granted to him, pending issue of such lease to enter into possession. Rule 17 imposes liability to pay revenue on such settlement. Rule 17A gives power to the deputy commissioner to increase or reduce at any time, either on an application or of its own, the revenue in proportion to the change in area of the lease as a result of gain by alluvial or by dereliction of a river, or loss by
Diluvian.
diluvian during the currency of the settlement. In other words, right of
Now,
entry-
this is the most important. In other
In
words,
other words, Scotty, right of entry into possession of government land is aged with a written lease or permission by deputy commissioner. They are entitled to pay revenue in terms of lease or permission. Any person who enters into possession otherwise than pursuant to Rule 16 is an encroacher into government vacant land. Rule 18(1) provides that. Subject as hereinafter provided, the deputy commissioner may eject any person from land over which no person has acquired the rights of proprietor, landholder, or settlement. Rest of the rules are not.
then you come to paragraph 5.
It is true, as pointed out by Sri Swami, that Mojadars have been given right to collect duty of miscellaneous land revenue in the appropriate cash box prescribed in the instruction, and that on collection, the Mojadar is enjoined to deposit the collection so made in the manner prescribed. The question is whether the person who enters into possession otherwise than in accordance with Rule 16 would be recognized to be a person who have duly entered into possession of the government wasteland, and thus entitled to be recognized in tozy possession of the land, even though they may have paid revenue to Mojadar. The Mojadar, as an agent of the government, cannot clock himself with any higher right than is given as an agent to collect revenue on behalf of the government, and has no power to create any right under Rule 16. This collection of land revenue from persons other than those covered by Rule 16, 17, and 17A would not confer any right on such persons in unauthorized event. At best, such collection must be only illegal collection, and it does not bind the government. A reading of Rule 16 clearly indicates its mandatory character.
There the
person-
problem arises
Yes.
for you.
Yes,
Yeah.
yes.
How many judgments you bring, the PIL for all these things. There, that is the line which is having the thing.
Okay.
Yes, then
The person is entitled to enter into the possession in two characters, namely settlement of the written lease granted by the Deputy Commissioner pursuant to the written application or by a written permission given by the Deputy Commissioner pending settlement. In either of the events, a person is entitled to enter into possession of government waste land, and from such person, the Mozadar is entitled to collect the revenue as contemplated in terms of these. Since Rule 17 or 17A gives express power to the Deputy Commissioner either to increase the revenue as specified in these or to reduce the revenue as circumstances warrant under Rule 17A. This would indicate that the Mozadar is a local revenue collection agent of the government, collect revenue only in respect of the persons who rightly and lawfully entered into possession of the land pursuant to the order in Rule 16. No other person has got any legitimacy to make any payment to the Mozadar, nor the Mozadar has any power to collect such land revenue from the trespasser, nor shall find the government which is contrary to the provisions of Rule 16. Any other interpretation would be clearly repugnant to the scheme of the relevant provisions of the regulation and the administrative instruction issued to the Mozadar for revenue collection do not override the statutory operation of the regulation. And the rule not to pay give legitimacy to his illegal act of Mozadar for which he would be liable to be disciplinary action. The High Court therefore was clearly in error in holding that Tojibahi revenue collected by Mozadar would amount to collection of revenue and that the possession of this person would not become unlawful and no action under Rule 18 is called for unless action is taken to terminate non-existent lease or to pass any proper order and then to recover possession of land from the enclosure in accordance with the provisions of the Act of Public Domain.
Then para 7 is your thing by which something can be given to you, which is the most relevant
Yes.
for you.
With regard to other cases, we think that since it is only an interim order passed by the High Court and no results have been recorded on the nature of possession of the respondent, the matter is remanded to the Deputy Commissioner concerned. He would issue notice to the respondent and after considering their objection, decide whether they have any right accord under Rule 16 as held in the order and then take action accordingly. The order of the High Court is
This is the
Lordship,
only
again-
line which
again,
helps you.
this, Regulation 16 will come into play before the Deputy Commissioner.
Huh?
Again, this 16 will come into play before the Deputy Commissioner.
So that
Remanded
is why I'm
back-
saying this line is the only
Only-
catch. Then you further read another line. Then last,
Sure.
similarly in civil appeal number.
Similarly, in civil appeal appeal SLPC was the matter is remanded to the Deputy Commissioner concerned who would give notice to the respondent, decide whether their possession in accordance with Rule 16 and would then take action thereof. So there is no list to this petitioner. There is no under section 16, regulation 16. This has not been issued to the petitioner. So therefore,
No.
if it is remanded back, it also nothing will.
So that is why instead of that, you take the 6 months.
Yes, Your Lordship, this has also been upheld by the Honorable Division Bench of Guwahati High Court in writ appeal 178 2019. Your Lordship, on last occasion. Mr.
Yes, that
Barbujari
is
had
where
submitted,
I've
Your
seen
Lordship.
it. The order was passed in November, given time till 30th of May.
Yes, Your
That is the
Lordship.
only thing which I can give you.
Yes, Your Lordship.
Only that. I can't help you otherwise.
Not-
No,
Some
giving,
relief they will get.
if this 7, if I take the help of 7 also to give it to you, it will have a problem because you don't have anything under 16.
Yeah.
And all the other judgments in the PIL, this judgment of the Supreme Court overrides,
Yes, yes.
and these have not been taken into consideration.
Yeah.
And as such, all judgments are in per incurium.
Yes, sir.
Yes, Mr. Nath, what do you have to say? On one hand, you are trying to throw out this petitioner. And on the other hand, why are you giving settlement to 3 persons and accepting their rent also, deposit of a house?
Because somehow that has happened. I can't go beyond the records. But the thing is that the land was in the year 662 or it is 69, 62. The land, particular land was allotted for the purpose of the TB hospital. It was with them,
With the TB hospital.
with the TB hospital.
No, I understand that.
And
But those are all of 2011. 2022 also you are passing orders.
but somehow those applications are processed, and
And you have taken the revenue also. Look at here, you have this petition.
yes, sir.
Yes, sir.
I have
No,
seen.
this 7618.
Yes, sir. In the affidavit, we have stated that.
No, not your affidavit. Their affidavit, you look here.
Lodge.
See the reply in the affidavit. Where is it?
860 or
Affidavit in reply. Kindly come here to page. Yes,
60 or
kindly
60.
come to the running page 60. You got it?
Lodge, I got
11/2/2022.
Lodge.
Why is the deputy commissioner doing all these things? On one hand, you are thinking of putting it as a TB hospital, the second medical college. And on the other hand, your revenue people are doing all these things and have accepted. And this is not done by this additional deputy commissioner. This has been done under the orders of the governor of Assam. Does it show a good picture of the state government state of affairs? More particularly the revenue department? Or is the revenue department more embroiled into the Gaubura appointment and changing the ages?
Lordship, actually,
Then they have forgotten about all other aspects.
the circle
Well, it
officer's
seems-
report was taken into consideration, Your Lordship, before passing this order. Circle officer's report was taken.
Then
Maybe there are some anomalies that circle.
but the government is going to acquire this. Now the settlement has already been given.
I spoke to them. They said that they are working on this, but either they will propose them some other land or it will be acquired. But it is not finalized. Yet, finalized. But no further, they whatever procedure they have already followed, it is in the pipeline. It will be at that stage. They will not move beyond that. That has been clarified by the
So
because
the pipeline has been stopped or it's still
it
in
is-
or
no, it
are
is-
still settlement proceedings going
no,
on?
it is stopped. It is stopped. Well, some applications are there.
Yes.
Those are
So the
under process.
applications of the petitioners you are not going to consider
No,
for
no
this
further.
land.
No further.
For,
No
for this
further.
particular problem.
No, no,
Under-
you may consider for some other land, but not this land.
Not under DAG number 97. It is not. It will not be considered.
So we take it that in lag number 97, the question of settlement being given to the petitioner does not arise.
No, not at all. At this stage, not at all.
What is this at this stage
No.
business?
Since
So I dismiss these petitions and tomorrow you are going to give it to somebody else?
no. What I would like to submit, after the land has been earmarked by the SDLSC for the second hospital, second medical college, now whatever process already it was initiated under process, everything will be solved at that stage. Nothing will proceed further. Because the land under DAG number 97 is required for the second medical college, and it will be for the second medical college only, not for any other purpose. Two settlement orders have been already given. Some others are under process. Whatever is the stage, that is the final ballot. It will not proceed further. They will not allow any land under DAG number 97 to any person, not to the petitioners present occupant or the petitioners who have already applied, or anybody. In fact, they have said that whatever has happened, it was happened wrongly, but that doesn't, since under their orders it was done, they just cannot say that. They have to either require or they have to offer the other. In fact, there are processes. They can.
Lordship, the minutes of the meeting was of 19 to 2022. And thereafter also some regarding settlement of land was proposed by the Deputy Commissioner, Sub-Divisional Officer.
Where?
At page 82 of my reply. On 17/3/2022. 82. Minus of the meeting held on 19 to 22, and this order has been issued on 17/3/22.
Look here, Mr. Nath again. Page 82.
Reply, more reply. More reply. Reply.
Reply.
Tomorrow, are you going to say that there are court orders and as such we have to give it? There are two options, Mr. Nath, for this. Either the Advocate General has to appear and give an undertaking that this land of 97 under no circumstances would further be allotted to any other private. Or there has to be an affidavit being given by the Commissioner and Secretary to the effect. Because otherwise, this is because I dismissed their petition. And then you are going to allot to a lot of other people.
Lordship, we'll do that because so far my interaction with the Deputy Commissioner is concerned. I have already submitted.
No, the Deputy Commissioner
Lordship.
keeps on changing.
True.
And the government
These
also
are-
keeps on changing. So there
these
has to
are-
be an undertaking because otherwise, the moment I dismiss the petition, you are going to throw these people out. And they will give an undertaking that they will remove, go away after 6 months. And then the government comes up with thing that we are going to give settlement of this land of 97 to all these people. Now, second medical college, we don't have the finance for that. You never know.
In fact, the
It
construction
keeps on changing. The government's mood.
construction is going on in full swing. Lord. That Lordship,
Construction where?
at that particular and which is enforcement.
These people are there.
And land is 50 bigha, Lord. More than 50 bigha.
And this is, no, not 50 bigha, it is 34 bighas.
No, it is some other lands are also their veterinary land and all
Total
these things.
97 dark, we are only concerned with 97.
97.
97 only has 34 bighas.
In fact, construction is going on in the other land where these encroachments are not there. But these persons are occupying 10 lesser, 15 lesser type like that. Possibly totally not encroachment on that. But I'll convey that. Lordship has indicated either the undertaking.
If the Advocate General is here today, is he here?
He is here.
So ask him to give me an undertaking, I'll put it on undertaking, dispose of the matters, if he wants to give. If he doesn't want to give, because earlier the Advocate General was supposed to appear in this matter, that is what has been. Because this court, after passing this order, this court doesn't want that you are giving settlement to others and thereby deprive these people.
But he may be in the midst of some matter in Potamaban.
Take it up at 2.
Lordship, if I have to just give the background and the entire thing.
He knows the background. He was supposed to appear in this matter earlier.
If Lordship,
Then Mr. R. Borpujari, this court said that it is not required for Advocate General. Then R. Borpujari was appeared, isn't it, madam? He knows. He knows because an undertaking has to be given.
true,
if this court has to dismiss, because otherwise, why should this court dismiss these petitions?
Look-
Until you consider their applications for that.
I pray my lord, maybe taken tomorrow at 10:30. my lord.
No,
I'll-
not
I'll
tomorrow.
apprise.
Tomorrow, this court, you know, this court is otherwise busy on motion and all these days. This matter, I have kept it as the first item today because of that. Because it does not inspire the confidence even after you have had the meeting on the particular date. Prior to that, you have passed an order on 11/2/2022, thereby giving settlement to one person. Then you have also held a meeting thereafter that you are going to have a second medical college. Thereafter also, this is the state of affairs in the office of the deputy commissioner.
They're not consistent. That's true. That's true.
Then therefore, there has to be a consistent stand by the government.
That has to be. There has to be.
Because what you are saying, that cannot be an undertaking by the state. It is only when the undertaking is either given by the advocate general or
Or by the
on
concerned
oath by the person concerned.
True, my lord.
Then they can just cannot. Because otherwise, why should this court dismiss the
Well,
petition of the
Lordship may take the
Two.
matter. True.
In this series, I have 4 petitioners and their DAG is different. Their DAG is 96.
96 is out. 96 is not government land.
It is government land.
Then they have taken steps.
Well, already they have filed Kobula, and out of this, my lord, I have another petitioner that was not listed in this. His name is not listed in this list. He has already been granted permission, allowed by the GMDA, my lord. He has already filed Kobula, and in the year 2007, his prayer is allowed
For what?
for that particular land he is occupying.
For what?
For to give patta, my lord.
Patta has been given.
No, not yet, my lord.
Settlement order has come.
No, my lord.
Then
Only
what
a
is the
list
right?
was, my lord, only a list was, my lord, published by the GMDA. That was, if this case was not listed.
No, what is the GMD business out here? This is the land of question of settlement by
my
the
lord,
revenue
for
authorities.
residential plot, my lord.
That is a permission.
Yes, permission is allowed.
Permissions are being given by the GMD. That does not, permission being granted by the GMD does not give you a settlement. Settlement has to be by the revenue authority.
Revenue authority. That
So
is
if
what-
that is not
but,
done, it is not done. But 96 also, the same problem arises.
same.
What is your right?
Already, my lord, one of my petitioner is residing there for 47 years, 48 years.
You want another 2 years undertaking to make it a what do you call, golden jubilee?
And another petitioner, one of the petitioner, my lord, already built up a 3-story building. And
We have
that
seen out there
SS and the
in the TV and also in many other places, we have seen that bigger the 4-story buildings have been broken by them. That is another aspect. But first of all, you have to have a right. Making a 3-story building or 4-story building does not have it.
already they have filed.
But only thing there, only worry is this, that this court, by an action by the state to remove you, should not to bring somebody else.
Yes.
They want to do it for public purpose, it's okay. But not for the purpose of giving settlement to somebody else. You want to do it for the purpose of a hospital, well and fine, you go ahead. But not at that, stating that to be a government hospital and then giving settlement to industrialists, you know. This court doesn't, yeah, we'll take it up at 2. That either the advocate general gives or then otherwise, why not we follow the same order which has been passed by Justice Buzalbur saying that no steps be taken unless you consider their application.
Item number 1, order no steps.
May Fizul,
Yes,
I have totally record logic. I have first time I have taken steps. But the direction is given for taking fresh steps, Lordship.
You have taken?
Steps not taken, but so far the respondent number 6, here Lordship, the prayer of the grievance of the petitioner to release salary for a particular period. The respondent number 6 is a headmaster of a school.
What do you want here in this
The name of
petition?
the have to strike off, Lordship, because
Headmaster Bongaigaon
yeah, so here
Vidya Mandir.
he has no business with the my payment of salary. His name may be strike off. That's not
And tomorrow you may say the non-royal certificate has not been given.
certificate.
Who is going to give the non-royal certificate?
PO, Lordship, block elementary education officer, either block elementary.
So you want to
education
strike off the name of respondent number
officer-
6?
Yes, no.
Okay. Heard Mr. A. Deka, the learned counsel appearing on behalf of the petitioner, and Mr. P.K. Bora appearing on behalf of the Elementary Education Department. Mr. A. Deka submits that taking into account the matter involved, the presence of the respondent number 6 is not necessary, and accordingly, the name of the respondent number 6 may be struck off. In view of the said submission, the name of the respondent number 6 has been struck off at the risk of the petition. This is the matter.
The authority, last occasion, the authority was directed to obtain instruction as to why the salary of the petitioner is not paid. But they have not yet to receive the instruction. Because it's a wrong method since 2000 for a particular period, although let's say,
Mr. Deka, what is the orders pass you see? All these while, Mr. N. Pukon so submits that the matter is under process for payment of area salary to the petitioner and therefore he pays for some time. So this is at the request of Mr. A. Deka leads the matter. This is what is going on.
Yes.
Then who is delaying the proceedings? You or the government?
next on the returnable that to the direction to obtain the instruction.
What is their area?
Let's see, from the date
Can
of
I go,
regularization
It will come
till
on.
the date of appeal.
Let the
to
matter be listed again on 27th of March 2023.
Lord.
In the meantime, the Learned Counsel for the Elementary Education Department shall also obtain the instructions as regards the as to when the payment of the area salary of the petitioner would be disbursed.
Keep look. Oblige.
Item number 2 and 3, part for admission.
Yes, Mr. Borua, does it help you?
Yes, my lord. And moreover, my lord, here order of passing the order of compulsory retirement, page 37. This is very selective. They have selected only those entries without taking into account the entire service. That is apparent from the.
So you have filed an affidavit in reply, bringing on record the others.
I finally apply affidavit reply
Huh?
regarding my lord that they paragraph 8 your lordship may see and ACRs for the year 2005. My reply dated 14/3.
However, the order of compulsory is thrown from retrospective effect when already the deponent issued order for a month.
Next line, however.
Huh?
Next line, however, the purported order of compulsory return was passed by respondent number
Without
3.
considering the entire service,
Yes.
ignoring the good and very good in the deponent's ACR's conference, and these aspects were not taken into account by the authority to form a definite.
That is the case. They have not they only selected their pilot taken into account for their satisfaction. So that way, my lord,
So how can this court look into this good, bad, and ugly thing?
this they have to bring into account, my lord, from their own opinion they have formed, my lord, from the order itself. The opinion itself formed on the basis of those they have mentioned in page 37 of the order. They say that
Where?
precedent period, page 37 of my report. It is apparent from their own record.
Page 37.
NHRL order dated 25/3/2020.
Whereas when so I have not attended his official duties. for
Seen and
allowed
perused the
to
following order.
leave without any permission, whereas the three of the above he has authorized. Now, what does this judgment say?
Judgment, my lord.
You've not read it
I have gone through, my lord.
because that is your judgment for your part.
Yes, yes.
That in lieu of initiating a departmental proceeding
Yes.
for the purpose of your termination or dismissal,
Yes.
they cannot pass an order of compulsory.
Yes. And that department proceeding without bringing into logical end, my lord. They have proceeded. And that is said to be, my lord, nullified. And another, my lord, another thing is that, my lord, para 24 of Lordship judgment, my lord, page 2023. Para 24, my lord, I found from
Of which judgment?
of the recent judgment, my lord, 2023 Supreme Court online.
Oh, only copy which I had, I gave it to you. Yes. Okay, I'll look it here.
Para 24, may I read it? My lord?
Yes, Mr. Sharma, you have a copy of that judgment?
No, Lord.
Oh.
May I read it, my lord? It will be here.
Just 1 minute. What is the name of the judgment?
My lord, name of the judgment is Captain Pramod Kumar Bajaj.
Ah, got it.
I found in Google also.
Yes, where is it?
Para 24, my lord.
Yes, Nankumar Sharma.
Yes, yes.
Verma.
Nan Kumar Verma versus State of Jharkhand. This court has once again highlighted the permissibility of asserting the existence of valid materials by a court for the authorities to pass an order of compulsory retirement and observe thus. It is also well settled that the formation of opinion for compulsory retirement is based on subjective satisfaction of the authority concerned. But such satisfaction must be based on a valid material. It is permissible for the court to ascertain whether a valid material exists or otherwise on which the subjective satisfaction of administrative authority is based. In the present matter, what we see is that the High Court, while holding that the track record and service record appellant was unsatisfactory, had selectively taken into consideration the service record for certain years only. This is the word, mother. While making extract of some contents of the 8 years. There appears to be some discrepancy. Now, in my case also, my lord, they have the authority, my lord, has selectively selected those entries, but those ignoring those entries which are available in the record, which are good and these are not taken. So the opinion itself is bad,
And what does it say in this judgment?
my lord.
Does it mention anything about the means when disciplinary proceedings should be taken, you can't go for compulsory retirement. That is the in fact the ratio in the judgment. You have gone through
Para
that.
37, no.
Huh?
Para 37.
Para 37. Yes. Having regard to the facts.
Having regard to the facts that a respondent did not take the disciplinary proceeding initiated against the appellants with logical conclusion and instead issue an order compulsory retiring him. This court does not seem it expedient to delve into the allegation level in the said charge memorandum. All the same, we have cursorily gone through the charge memorandum that mentioned 3 charges. One alleging the appellant failed to seek permission from the department to purchase a flat in related to matrimonial dispute between him and his estranged wife. And the second one is in respect of the allegation of bigamy level against him by estranged, We have already noted earlier that during the course of the material dispute, parties have arrived at a settlement of that was agreed to be given to why was not pursued by the appellant, but by his brother. This fact is amply borne out from the documents placed on record. The matrimonial dispute between the parties stood close on a decree of divorce being granted on the basis of mutual consent. The respondents were also cognizant of the said fact. It is apparent from the contents of OM dated so and so. This record entirely that the said allegation level wise had not been established. The third charge was relating to appellant having attended court hearings without sanction leave. However, the disciplinary proceeding initiated against the appellant on 17 July 19 were abandoned by the respondent on the order of compulsory retirement being passed against him is less than 3 months reckoned from on so and so much. So here also, my lord, in my case also, disciplinary proceeding were abandoned. Para 38 is biased.
Yes, you were compulsorily retired on
I was retired on compulsory with effect from retrospective date dated 29/2/2020.
29/2/2020.
The order was passed subsequently on 25th March 2020, and it was communicated to me in the month of May.
That mistake was there initially, that voluntary retirement. The petitioner was directed to go on voluntary retirement and 3 months notice was there. Thereafter, by way of a corrigendum lordship, it was rectified. She was directed to go on compulsory retirement, taking into consideration the earlier date. That mistake is there. The 3 months, that period salary she will get.
No,
Not mistake,
that she will get, it's
Lordship.
okay, I'm not
And,
on that.
yes, Lord.
But
I'm
the
just
question is-
clarifying the query.
But the question is, if you had these allegations, why haven't you gone for disciplinary action
Lordship.
and instead gone for the
In
compulsory?
2023, the recent judgment, Lordship, I have also, but Lordship, I have not gone through properly, but I have seen that it should not be in lieu of punitive action, Lordship.
No, if, why is a compulsory retirement done? A person who is deadwood,
Lordship.
that is the basic
Without the
reason.
deadwood, that is the concept.
To remove the deadwood,
Yes.
that is the reason why.
But from
But the allegations in the compulsory retirement order is different. There's an allegations of the, it
Yes.
seems to be punitive.
yes, Lordship. It should have been done, Lordship. The discipline, by way of a disciplinary proceeding, the petitioner should be removed from her service. It should be done. Most probably a lenient view is taken, as because, Lordship, had it been a disciplinary proceeding, the punishment is imposed. Certain curtailment is there regarding the benefits which she is entitled. But in case of compulsory retirement, there is no such curtailment. Otherwise, Lordship, in one case, if your Lordship go by my additional affidavit, in one case she even admits it, but in spite of that, Lordship, a lenient view was taken and she was allowed to continue in her service.
Now, Mr. Counsel, would you take the risk of going for a disciplinary inquiry?
Well, if they do this proceeding, well, then I have to pay. But it cannot be a shortcut to the departmental proceeding.
Understood.
Yes.
But if there is a disciplinary proceedings, there will be, the consequences will be more harsh.
Yes.
Taking into account the allegations which are against.
But here I approached before because when they pass the voluntary
No,
retirement
that
order-
is okay.
Yes.
Mr. Buru, I have to make it very clear that you don't have a case. You may at best get 3 months. But it is because of that allegation which you have made that in lieu of departmental proceedings, they have initiated the compulsory retirement. Because if you do that, yes, compulsory retirement, the pension which is there, I think there will be a bit reduced to a particular level. But otherwise, other benefits you keep on getting. But if it is the case of disciplinary proceedings, it may take, you know what, they may very well suspend you out there and keep it out there and thereafter initiate disciplinary proceedings. And once it is being held, you may be removed and may not get your pension or anything to that effect. Would you like to confer with your client once to go ahead with this thing? Yes, this court may very well say that, okay, the compulsory retirement is valid. So they may initiate proceedings for discipline. Would she like to do that?
If they have to for good and sufficient reason only, they will have to initiate press matter.
They would. There's no, the moment that is done, because the moment you are saying
Yes.
that in lieu of departmental disciplinary proceedings, they have gone for compulsory retirement. And if I uphold your submission there, that I will be definitely have to say that this is a case, may have been a case of departmental or disciplinary proceedings, and as such they shouldn't have gone for compulsory. Then obviously it is apparent on the face of it they are going to go ahead with the disciplinary.
My case was filed regarding formation of opinion. Taking into account the Supreme Court Vaikunta Das judgment, my lord, they have to take the entire service record. Now here apparently they have not taken the entire service record. What they have taken only subjectively, they have selected only those entries which are less favorable to me, ignoring all those good entries.
So you don't want to travel in the path of disciplinary inquiry and compulsory retirement. You don't want to go with it.
Because they have
But your
abandoned-
submission earlier was on that.
No, I was confining to their argument that my record by the last order. Your
So
lordship,
you're therefore the submission is
yes,
that the compulsory retirement has to be taken by taking into account the entire
yes,
entire records.
Yes.
But what they have done, they have taken only selectively without taking into
Yes.
account the remaining.
and that I placed one judgment of state of Gujarat, my lord, very categorically, my lord, paragraph 17, paragraph 7, my lord. And not only that, my lord, it says, my lord, the both record has to be considered would necessarily include the entries both favorable and adverse. Para 7, my lord. And it's a Roman 3. Para 7.
Principles of natural justice have no place in the context of the order of compulsory. This doesn't mean that the judiciary is excused. While the High Court or the AIO could not examine the matter as an appellate court, they may interfere if their part is not A. It passed a malafide that it is based on no evidence or it arbitrary in the sense that no rule would have from the
requisite on the given material. You have to take all entire record. my lord. Para 7 and Roman 3, my lord.
Government of the man shall have to consider the entire record of the service before taking a decision in the matter. Attaching more importance to the record and performance during the lecture. Now, your later years, as per your affidavit, which you have filed, you had good ACR. What was your ranking in the ACR in 2019?
Well, what I am pointing out from this that in the order passed by compulsory retirement,
It's a matter of knowledge only, Lord, not record.
It's okay.
Lordship.
It's okay.
Sorry.
in the method.
Oh, now, what do you have stated in paragraph number 8?
Yes. But I have
That the
stated-
deponents ACR for 2005, 6, 7, 9, 14, 16, 17, and 19, these aspects were not taken into.
yes, while forming the opinion.
Understood. But what were their ratings at that point of time? Normally, these are being intimated to you. Are you aware of? You said that ignoring the good and very good.
No, what I'm saying, my lord, that while forming the opinion, these particular years were not taken into account to form a complete opinion. What they form opinion is on the satisfaction of those selective entries, which is, my lord, violation of the Supreme Court judgment, my lord. Both favorable and non-favorable, both entry has to be taken together. And then he has to independently apply his mind and take a opinion. Now, opinion was hurriedly done, my lord. Only going through it. And if your lordship will see the entry at 2017, I found it is not a order, it's only a so-called notice. So on perusal of so-called notice, he formed an opinion. This, my lord, last order of the mentioned in the compulsory retirement order dated 14/11,
Page
page 37, my lord,
37.
of my writ petition.
Ah.
If your lordship will see the orders below, my lord, dated 9/10/2018 and order dated 14/11/2018.
Hmm.
These are just so-called notices, my lord. So-called notices, and without considering the subsequent orders, which are not in their record, he has formed the opinion merely on the basis of so-called notice. And I have said in my affidavit that I have not received the so-called also of 14/11/2018. So this aspect is, my lord, the Malafide looms, man.
No, is it your case that the other ACRs for those as mentioned in paragraph number 8 of your reply
Yes.
were good and very good?
Well, without commenting on that, I will say.
No. You have filed it on affidavit. Don't make it.
Yes, yes.
Is it your statement to that effect?
These are good because,
No, because business. The simple is yes or no.
yes, man, because.
So they were good and very good
Yes.
in these years,
Yes.
which have not been taken into consideration.
Yes. And in their affidavit also, they are silent. They are required to brought into account all these matters or by last order.
No, they may very well they may have looked into the earlier period also.
No, they have brought only those selected orders based on which they have passed this order, my lord. Kindly see, my lord, their affidavit. I've gone through their annexure, my lord. Only those entries which they have found to be adverse to me. And some of them are only proposed notice, my lord. That's why, my lord, your lordship will kindly see that page 60 of their affidavit. It's only a so-called notice. Page 60 of their additional affidavit, 14/11. This was only a so-called notice. Subsequent order, nothing has been, my lord, independent.
May I please from my
assessed.
affidavit, lordship? As because my learned friend has shown only one document. If your lordship go to the next page, page 61.
Page?
Page 61, as because in page 60, annexure X11.
Yes.
You are therefore directed to submit your reply within 3 days of the receipt of this
Page
letter.
61.
60 is the running page, lordship, of
Wait.
my additional affidavit, which was that annexure
No,
X11.
that page 60 is what? It is the first affidavit.
No, lordship, an additional affidavit.
Filed by respondent too much. Very-
Respondent number 2 pursuant to your lordship's direction.
Oh, that one.
Yes. My learned friend is relying on page 60. Annexure X11.
Act 1.
X11. My learned friend is just now relying on that page as because
Okay, now
according
what do you want to rely on? Act?
X11. My
You want to
learned
throw
friend
Act
just
11.
yes. Page 60. Running page.
Yes.
With reference to the above, you have been directed to submit your written reply of so cause by 15th of October 2018. That is the page 59. But till date, after a lapse of 1 month, you have failed to submit any reply, which is gross indiscipline and negligence of duties. You are therefore directed to submit reply within 3 days. Then your lordship may come to the next page.
Yeah.
Whereas Srimati so-and-so, senior assistant of this office, was issued so-called notice by letter so-and-so, dated so-and-so, directing her to submit a written reply within 15th of October 2018. for her unauthorized absence in duty. Since no reply has been received till 14th of 2018, a reminder was issued, that is at page 60, to her by letter dated so and so, and to submit a reply within 3 days of the receipt of that letter. But till date, no reply has been received from her, which is tantamount to her tacit acceptance of her gross negligence of duty. Whereas as per provision of Rule 17(1) of the fundamental rules laid down that an incumbent who is absent from duty without any authority shall not be entitled to pay an allowance during the period of absence. Srimati so and so is found absent from duties with effect from 10th of July to 13th of July, 18th of July to 21st of July and 30th of August, and with effect from 20th September to 19th of November without any authority. Hence, she is entitled to pay an allowance, not entitled to pay an allowances. So this, her pay and allowances was deducted.
Now
She was
this-
not allowed to. She has not challenged it.
I'm
So
not
it comes to
required
the
challenge, my lord.
finality.
Well, what happened, this order is not part of the opinion forming by them. That is my submission. my lord. They have not taken into account this order, my lord, in their compulsory.
You won that.
This is not here, my lord.
No,
They have-
you won that.
Then only totality of the opinion will be formed, my lord. It's not available in their compulsory retirement. That is my submission. my lord. They cannot substitute the reason subsequently by the.
Give me that judgment.
my lord. So my submission is that opinion has to be formed in totality of.
Hearing complete judgment reserved.
I am also relaying to judgment's lordship. 2021 SCC 801 Rammurthy Yadav, and second one is lordship 2022 5 SCC page
100.
100.
I have it. It is Om Prakash.
Yes, Lord.
Ram.
Rammurthy Yadav is 2020.
You have a copy?
Yes, Lordship.
And what other judgments you are relying?
Well, I relied on this.
You are relying on this one?
Yes, paragraph 7, my lord. That Vaikunta Nas is discussed. my lord.
Yes, 2001 PSCC.
Yes, my lord.
And
Para 7, Roman 3, 4, where my lord both favorable and adverse entry has to be taken. Then another judgment, my lord. It's year 1981. Year 1981 Supreme Court, page 70.
That Rammurthy Yadav, he was a CJM Lordship because of the acquittal of a person convict Lordship. That without conducting the departmental proceeding, they have come to the conclusion. For
Paragraph?
Paragraph, my one.
no,
is my-
your
Paragraph. I am relying on the paragraph 13 Lordship.
of Rammurthy
No, Om Prakash.
and
And in Rammurthy Lordship, I am relying on this paragraph 6. The scope of
okay, you are relying on which the fundamental.
Year
rule.
1981, my lord. These are all
Appropriate
fellow
copy of
setting aside the
fundamental-
compulsory. I am relying only those paragraph number. And
Huh?
paragraph 15, my lord.
15
Yes, 1 5.
of this Justice Krishna judgment.
Yes, ma'am.
The appellant was promoted only in 1961.
Yes.
Paragraph 15.
Yes, yes. Then subsequently, the next page also, my lord, your lordship will see this one.
A perusal of the extracts of the constitution will prove that there was no adverse because these are sufficient.
Yes.
In the adverse Okay. Para, this one, no?
Yes,
The last, I think.
yes,
One wonders.
yes. That is important.
Anything else?
Regarding my next item. Item 3 is also connected.
That I know.
In this case, my lord, my submission will be that, my lord, entire,
Your submission, I've got it. Your submission is to the effect that they were required to take into account the various materials. They have not done so. And as such, the subjective satisfaction so found was not in accordance with law, for which that compulsory retirement needs to be satisfied.
because the opinion was-
Without going into the question as to it should be in lieu of department, because that will open another Pandora's box, which may be difficult for you.
entire record was not taken, my lord, while forming the opinion. That is,
You got a record?
and my-
This entire record is not available, Lord. The record which is available with me, I have already annexed in my additional affidavit. And I'm also in Prakash case, Lordship, I am also relying paragraph 4 and 6. Lord.
What does it say?
4, it's a relying on the judgment delivered in 1990. The court approves the earlier judgment of this court reported of the Union of India so and so in 1982 SCC 15. An order of compulsory retirement on one hand causes no Lord,
Paragraph?
paragraph 4, where reiterating the judgment of reported in 1980, paragraph 12.
Mr. Sharma,
Lord.
tell me, yes, with due respect to the Supreme Court,
Lord.
wouldn't her qualifying service be effective with a compulsory?
Seems to be not, Lordship.
Why?
Seems to be not. That's because, Lordship, had it been a punishment, dismissal,
Forget about the punishment.
Lordship.
We are
In,
concerned with compulsory.
in case of a compulsory retirement, she is entitled for the whole
He's
pension.
50. What is your age?
at now, my lord, 58, my lord,
50?
8,
At that time, she is
55.
And what is your retirement age?
I'm going to retire in 2025.
20?
that period. Seems to-
Now, what? As on the date of compulsory retirement, how many years of service you have put?
I have already completed 55 years from
How many years of service you have put?
uh,
30?
I was joined in 1985. I have to count my lord.
And
1985. I was-
1985 is 15 years and 20, 35 years.
Yes.
Beyond 35 years, there's no further pension. Pension is there till 35 years. The limit is 35 years. So under such circumstances, you will be entitled to the full pension.
Yes. She's and I think she's also getting it.
No, that is the problem, my lord. I have taken loan, my lord. Everything I have annexed the documents. The bank is before me. Not a single penny they have paid.
No, that is loan is another aspect of the matter. How can you bring the loan aspect out?
No, he is saying for survival.
Tomorrow you may say that I have built a house. How do I have half constructed my
Pension
house?
is not paid till now.
Huh?
Not a single penny for pension they have processed.
They have not paid you.
No, my lord. Not
They want
till
to
now.
pay you the entire salary, I suppose.
Lordship.
Is it?
Lordship.
You have not paid the pension. You want to pay the entire salary.
And that is why this is the hardship. Severe hardship. Lady without
Otherwise,
widow lady.
Lordship, why it is not paid, but he should get pension, Lordship.
Have you mentioned a statement that you have not even got the pension?
Yes, madam. In one of my affidavit, madam.
You
I
have
have
mentioned it, na?
Yes. Earlier affidavit I have mentioned. When I have last annexure also I have annexed.
Why it is not paid? Maybe some other reasons.
No,
may
well,
also
then
be
if he
there.
has made
But that
a
is-
if
that is-
this court is not inclined to accede to the prayer of the petitioner in the judgment, then this court will have to direct that the pension has to be paid.
Yes, that is okay.
Now, there's one statement also, no?
I have NFB loan again in my affidavit.
No,
my
No, no,
Lordship,
not the
regarding
loan.
pension,
Don't
Lordship,
bring
there
the
is no
loan
statement, I
aspect
think.
again.
Regarding only loan part, that she is suffering a lot as
No, no,
because she is-
about pension, have you mentioned?
regarding pension, most probably it's not there, Lordship.
Okay, we'll take his oral statement.
Had it been paid then my lord, I would have brought.
Huh?
I have obtained the instruction. Yesterday also it was not paid.
It should have approved, Lordship.
Huh?
In
David.
2020, Lordship, there was the compulsory retirement order. 3 years have already gone by. It should have approved already.
No, I have approached my lord. Because of my loan liability, I approached. But the authority is saying that because of this case, they were not. Although
3
there
years
is no
she is
stay order.
sitting idle, Lord.
And the
Very
next
well.
Item 3 is my lord regarding my lord eviction from my
Quarter.
quarter.
Huh?
Item 3, my lord, connected method.
You're still,
There's a order of this court has passed on 22nd 9, my lord, in very much. Because under service condition, I was there, my lord. At that point of time,
but was the compulsory retirement order stayed? If it was not stayed, how can you stay?
eviction notice was sent. Eviction
That-
from quarter.
By way of a different writ petition, Lordship, that order was taken.
Which one?
That regarding her vacation order, Lordship, from her quarter.
That is state, my lord, at that point of time, only voluntary retirement order was there. They
So you are going to pay the rent now.
that consequently follow, my lord.
You have to pay the rent.
Yes.
Only 6 months is allowed, Lordship. Beyond that, Lordship, he has to pay.
A rent at the standard market rate.
No, man. As per the, my lord,
How much?
service condition, my lord.
Service and how could you? But by virtue of a court's order, you were staying, na?
Yes, yes, not by,
Then,
Yes, Lordship. That protection is there, Lord.
okay.
Much obliged.
obliged.
No, 3031, there is no disposal. Is it so?
3031, yes, it is disposed of.
Why an order dated?
In the
Oh, yes.
ID order dated, Lordship, 6th of November 2020.
Yes. So what is your case?
My curiosity is that although the service of the petitioner number, sorry, respondent number 7 and 8 is provincialized, that is wrong. Wrong in a sense, Lordship, the respondent number 7, he is teaching purely science, and that is admitted in the earlier petition. After
Now,
disposal
what
of
is your case out here in this matter?
Lordship, the service of the respondent number 7
Take no-
is provincialized in my place, although I am entitled. Therefore, Lordship, may kindly come to page 29. Page 29.
Is it for area salary?
No,
Then why these matters are before this court?
my lord, this is for provincialized. I am
So,
not here,
it
I
is-
am challenging the provincialization order of the rescue number 7 and 8.
Let this matter go to the appropriate bench. It's the bench to matter.
Lord,
Let the matter be litigated before the appropriate.
but the date may be given. The date may be given because I am entitled, but because of some wrong communication, I am deprived.
On 22nd of March.
Blessed, applied.
Yes, Mr. Pukon,
Item 6,
your matter.
May I please, Lord?
Hmm.
Lord, I have been instructed by Mr. Das to continue the argument from where it was left on the earlier occasion.
Hmm?
I have been instructed by Mr. Das to continue the argument from where it was left on the earlier day. And I proceed with it.
What?
My lord, regarding the argument, my lord. I'm proceeding with the argument. my lord.
You want to make the argument?
Yes, ma'am.
Okay, make it. This court has made it very clear on the last occasion, stating that the case of the petitioner in brief, that the petitioner having completed 1/2 of the maximum term has a statutory right to be entitled for bail under section 436A of the CRP. It is the case of the petitioner that the court below did not consider the said aspect of the matter, rather by relying upon an observation being made by this court, have rejected the prayer for bail in terms with section 436A of the CRP. It is the further case of the petitioner on and from 17/8/2022. It is the requirement of law that has to be recording of reasons for which the petitioner should be remanded back to the custody after the petitioner have completed 1/2 of the term, and therefore the further detention of the petitioner is an illegal detention and accordingly violates the constitutional mandate under Article 20. On the other hand, Mr. M. Pukon, the learned public prosecutor for the state, submitted that the coordinate bench of this court by order in bail petition have already decided that in the attending facts of the case, the petitioner is not entitled to bail in terms with section 436A of the CRPC. The learned public prosecutor further relied upon the observation of this court in paragraph number 10 and 11 of the state order dated 12. The learned public prosecutor therefore submitted that the court below was justified in passing the order, thereby rejecting the application in view of the categorical findings of this court, whereby the petitioner's prayer for consideration of bail in terms with section 436A of the CRPC has been rejected. So that is the submission. Now, the judgment by Justice Bottakut, more particularly in paragraph number 10 and 11, categorically holds that you are not entitled to the benefit under 436A. And the court below could do nothing but to follow that. Now, what is your case for 436A?
Yes, ma'am.
After this court having held that in the attending fact, because why the court held on those facts?
Well,
is it your case that the whole those facts also under 436A, the court has to cannot set the same parameters which are otherwise there in 438 and 439.
Right.
Is that your case?
For that, my lord, I would like to correct, Lord.
If that is so, then only this court can do it.
Yes,
Nothing more than that.
already the coordinate bench, my lord, they already decided the matter. And perusing the materials, the learned trial court also decided the same matter. Now, whether this argument before this honorable court is, my lord, the maintainable or not.
It can only be possible if you say that 436A, the power is different. which cannot be the same power which is there in 438 and 439. 438 and 439 is a different of 437.
Right.
Is a different power, which has to be looked into on these facts. As to these are the parameters, there is the chance that this person may abscond, or there is a question which may happen out there regarding the tempering of evidence and all those aspects of the matter. Thus, 436A gives you another power or another authority by which your case has to be separately taken, taking into account that you have already completed one half of the prison period.
But on that account, my lord, firstly, I would like to draw your lordship's attention in their opposition. In their opposition, they have categorically made statements which are contrary to the present fact or stage of the trial, and which has a bearing on my 436A application. And my lord, a perusal of the order, which is annexed at page 177, which is what is fallen from your lordship is a perusal of paragraph 7 of the judgment
Huh?
of that order 21-9 order at page 179. And let me kindly take paragraph 7. And there is a opposition. My lord will keep the opposition, and my lord, I will have to refer to the opposition also while submitting on the judgment. The opposition is there.
What opposition?
The opposition filed by the
My lord, last occasion, what happened, my lord, when the matter was placed before this honorable court, my lord, directed me. So if you have any written objection, you can file. Any written objection is
In
written
this
objection
matter?
in this case.
In
But
this case,
written objection by me, my lord.
in
It's
this
not
case,
not an affidavit opposition, it's a written objection.
written submission.
Yes, written submission.
Written submission has is a different thing.
My lord.
How can you go on a written submission on question of facts?
My lord, yes.
It is written
I
Facts
have
will
filed
dep-
only on.
facts in the case will depend either on affidavit, on
Yes.
evidence or affidavit,
Yes, my.
by way of evidence, by way of affidavit.
My lord.
Yes,
It's not an
even-
affidavit, my lord.
Even my lord, even if I filed a written objection, the averments which are made in
This
respect
can't be
of
said to
fact-
be averment. These are submissions.
Well, even the submissions
Yes.
made on the well, even if the is taken to be a submission on facts, those has to be brought before this honorable court. My lord.
By way of an
Because-
affidavit, if it is not brought, how can this court
Yes.
look into those?
Correct, my.
My lord, this is a written objection that
This
was
is
there
not a
filed on
written
record.
objection. Who is there a deponent?
No. No,
Well,
it's
it has
only
been
filed by me, my
the-
lord.
Filed by the learned PP. My lord.
Then
Well,
PP has
All right,
submitted.
I have filed, my lord, only on the
I will-
ground that, my lord, this honorable court directed me to, you have filed an objection or a written submission. That's why I'm fine. It is not an affidavit on oath, my.
I will submit on my petition on paragraph 7, my lord. I took my kindly take up paragraph 7 at page 179. May I place it, ma'am? Mr. Das, the senior counsel appearing for the accused petitioner, submitted that.
And Mr.
accused-
Counsel, you also have to take note of, if the facts are different, if you have any problem with the facts,
My lord,
what he has submitted before that court,
Well.
wouldn't that be a case for another aspect of the matter? That it would be a case of either review or you have to go to the SLP?
Yes, correct, my.
Sir, this is a written objection filed in this criminal petition, ma'am.
Understood. So can this court sit over that or that court's order?
No, my lord, I'm not onto that. I'm onto the application of applicability of 436A, and whether my case is whether the observations made in paragraph 9 and 10, particularly in paragraph 10, can be treated as a obiter, or was it a necessary issue? Is it, my lord, my case is this is an obiter, and this was never the issue to be decided by the High Court under 439, because my application was filed in the month of February 2022, and the petitioner completed the half term only in the month of August 2020. So while in the process of deliberation of the bail hearing, my lord, the petitioner completed the half term, and a submission was made that despite the petitioner being completed half term, the petitioner is facing long incarceration, and in light of Article 21 and his right to be under Article 21, he should be released. And the judgments which was cited, which was referred by the petitioner in the earlier order, none of these judgments referred to 436. And the paragraph 10, which has been referred in this judgment, my lord, the observation that this paragraph was taken from the written note of argument that was submitted by the prosecutor. So we have not challenged that. We did not file a review. We did not go for SLP. We considered with the order. In terms of paragraph 19, we were given a handle, my lord, to apply for a fresh bail application before the trial court at the appropriate stage, subject to certain conditions being fulfilled. Now, we complied with the order. We accepted the order. We complied with the conditions, and upon the appropriate stage, we filed a bail application. And this 436A application was moved for the first time by the petition. And my lord, we kindly appreciate, while the earlier 439 application was pending before the High Court, which was filed in February, in the interregnum, the petitioner completed the half. So we could not file a 436A application while the 439 application was pending, which is why we made a categoric submission before the in the earlier bail proceeding that we are not on 436. My lord will decide on the merit of the case under 439. And subject to that, my lord, the order of rejection, which was passed by the learned trial court on my 436 application, is not on merit, my lord. Is on merit, my lord. He has given a reasoning. The learned trial court has given a reasoning why my 436 application is not to be considered. It is not that because the High Court has already rejected, therefore I am not obliged or I am not inclined to release the petitioner on bail. That was not the case. He has cited, the learned trial court has cited a reason, given a reason.
What is the reason?
Order. My lord?
What is the reason?
Yes, my lord. My lord, the reason being is that the prosecution has already examined Vinita Rinja as an approver of the case, but had yet to examine other officials of APS. Besides, the accused is a senior office bearer of satsang within bracket Ritik, and the prosecution has to examine some persons who are associated with satsang. Before examining, my lord, this is at page 266 to 273, relevant at page 273, my lord. Plastic folder. Well, in the plastic folder, there is a note which I have submitted yesterday.
It's okay. You give me that other one. You are reading the page.
I'm reading from page 273, my lord.
Yes.
I have perused second paragraph, my lord, page 273. I have perused the decision relied on by the learned counsel for the accused. As the Guwahati High Court has considered the plea of the accused petitioner under 436A and rejected the bail prayer of the accused, I find no reason to consider the same plea subsequently. Now, my lord, next line, my lord. I'm into the next line, my lord. The Honorable High Court, in its order dated 21/9, directed this court to consider the bail prayer of the accused at an appropriate stage of trial of the case in accordance with law. So, this court is bound to obey the direction of the Honorable Guwahati High Court. Now, while the trial court proceeds, as the case has been taken on day-to-day basis and the prosecution has examined a good number of witnesses and is yet to examine some of the most material witnesses, and the accused is an influential person having the capability to influence the witnesses like the employees of APSC who were once his subordinates and the members of Satsang, I am of the considered view that this is not the appropriate stage of the trial to consider the bail prayer of the accused in his favor, and his continued detention is necessary. So, madam, there is a finding and there is a reason.
Yes.
Hence, the bail petition filed by the accused is rejected. So, my lord, in terms of the earlier High Court order, we accepted the order, we complied with the direction, we waited for the appropriate stage. And
Now, what do
after-
you say about page 100 and the last line at page 183?
183, Lord. Therefore,
Last
the accused petitioner, from the point of view of the opposite proviso of the 436 of IPC, as well as attending facts and circumstances that emerge from the evidence collected by the investigating agency in the case at present stage of the trial, is not entitled to be released on bail. But our submission is, my lord, this 436A application, the power under 436A, if my lord may kindly take up the section 1, the term High Court has been defined separately under 2E of the CRP, but the term court has not been defined. And under 436A, the language used is the court. So, my lord, the powers conferred under 436A is specifically distinguishable. Man. This is not a case that we can file a 436A
So what did you
application.
do? The same person, you had the case of 167 too.
Well,
Remember?
yes, ma'am.
A case called
Yes, ma'am.
Supreme Court.
Yes, ma'am.
There, you did not file an application
My lord.
for grant of default bail, if you remember.
Yes, my lord. A oral submission was made before the High Court.
And the Supreme Court say
Yes.
that the oral submissions so made by the High Court before the High Court should have been taken by the High Court at that point of time.
My lord.
Although there was nothing out there, and in view of the fact that the bail being a question of liberty under 21,
Well.
so the court should have taken it.
Well.
Now, how do you reconcile these two aspects of the matter?
Yes, my lord. My lord, reading of 436A, there are two aspects. One, the first,
I understand your
Section, my
point. Your submission is this. First and foremost, the court was called upon to decide 439 application.
my lord.
The issue was never 436A.
Right.
And as such, whatever decision is there cannot be said to be a precedent and thereby binding upon either the lower court or the court.
Right.
That is your submission.
Right.
Secondly, at best it can be said to be an obiter and it is not a ratio. And under such circumstances, it cannot be treated to be a precedent.
Right.
This is your.
Right.
Your second submission is, look here, 436A stipulates that the word court means the court which is presently in trial of the matter, whoever it is, and can be a high court. So therefore, the high court for the first time cannot take 436A.
My lord.
Isn't it your submission?
Yes, ma'am.
But my question, Mr. It's simple, which I have said on the last occasion. Let us assume that all these things, you are trying to impress upon the court that the trial court, while passing the order, did not take into account the observations of the court,
Right.
of this high court,
Right.
and independently has also given this.
Right.
This, in the opinion of this court, is a fallacious argument, taking into account that the trial court had duly taken that aspect of the matter. Therefore, I asked you on the last occasion also, you have to show me that when you are taking up a 437, 438 or 439, the considerations which are there could be different in the case of 436A because the person has already spent half of the time, of the one half of the period for the purpose of which is required for his entire prison time in respect to the offense, he have already spent. And under such circumstances, this is a separate provision which has been culled out. See, it's A.
Well,
A means it has come up most probably by way of an amendment by which the legislature must have thought that yes, a person who has spent half of the time, he normally should be granted the bail.
Well,
because he has already suffered. A person is in a criminal case, a person concerned cannot be said to be he is only termed as an accused, not a convict.
Well.
The reason is that he is only accused of an offense. So when he is just an accused, we have sent half away, grant him the bail. That is why this amendment was brought in.
Well.
You have to impress this court on that aspect of the matter. Don't go into these aspects of the matter.
I'm coming to it, my lord.
Yes, come to
436.
that. I made it on the last occasion also clear.
Well.
You have to show why 436A has come in.
Well.
Then you give it. This question of a person, yes, just for example, a trial may go for 20 years. On account of the fault of the prosecution, they may not have been able to file a charge sheet, or for the purpose, after filing the charge sheet, they may not be getting the witnesses also. Is it the thing that the person will languish out there in the jail? Yes, it happens out there in other states. It keeps on happening. But there is this specific power which is given under 436A. So under such circumstances, this is a legislative mandate. And when a person does or completes one half of the period, this is an exceptional circumstances on which he has to.
Right.
Just for example, 167. Earlier it was how much? There was no period.
15 days, my lord.
No, prior to that. There was no period out there, 24 hours. You could only keep the person for 24 hours. Later on, it thought that 15 days. Then it has been enlarged to 90 days.
Well.
This is how it has developed.
Yes.
You couldn't keep a person beyond 24 hours initially, when initially 167 had come. Isn't it? So this power, which is given under 436A, it's a specific power. It holds the circumstance which is given under 437, 438, or 439.
Right.
That is why we see the language. Where is that? 436, yes. Where a person has, during the period of investigation, inquiry, or trial. See, the CRPC has three things. Isn't it so? One is the investigation, a particular chapter given. One is inquiry, and the other is trial.
Right.
Under this code of an offense under any law, not be an offense for which the punishment of death has been specified as one of the punishment under law, undergone detention for a period extending up to one half of the maximum period of the imprisonment specified for that offense under that law, he shall be released by the court on his personal bond with or without sureties. Why is the question of a personal bond is being used? Because of the fact that the person has already suffered. Then you see, provided that the court may, after hearing the public prosecutor and for reasons to be recorded in writing, order the continued detention of such person for a period longer than one half, or release him on bail instead of the personal bond with or without sureties. Meaning thereby that further conditions can be imported.
Well.
Or it may be further extended after hearing the public prosecutor. Because he may have some objection.
Well.
Just for in cases like NDPS,
Well.
wherein the normal period is 180 days. But if the public prosecutor out there comes up and files an objection to that effect, stating thereby, no, we need it for a further period of that, the court can enlarge the period beyond 180 days to a period of 1 year. So under such circumstances, in this case also, it is the public prosecutor who may very well, that is why the reason why public prosecutor in that case was asked to file a written objection. Get the point?
Well.
That is the reason why. By this.
Well.
Then. Yeah, therefore it is like.
My lord, in the
Hearing.
proviso part, my lord.
Huh?
In the proviso part, my lord,
Yes.
there is a distinguishable difference, my lord.
Mm.
In the first paragraph, on his personal bond,
Yes.
and on the second paragraph, instead of the personal bond.
Yes.
So the moment the proviso comes into picture, the question of being released on his personal bond goes. Because on proviso says, instead of personal bond.
Hmm.
With or without surety.
Hmm.
And my lord, the second part is or release him on bail. So either the trial court or the court will exercise its power under 436A proviso to record a reason in writing or to authorize the
No.
further detention.
You look it in the other line. A person completing one half of the period is normally entitled to be given or sent or given the bail on personal bond with or without surety.
My lord.
An exception is being carved out, meaning thereby an exception subject to recording of reasons.
Right.
Just for example, there are many cases where you see wherein there has been stated a trial has to be completed within a period of 6 months.
Right.
And if you want to extend it, you have to record reasons.
Right.
So this is an exception being carved out to the effect that you want to detain him further, then you have to give him more reasons
My lord.
why you want it.
And the proviso also
The
says
rule
release
is
him on bail.
to give.
My lord. Then the-
However, by recording reasons you can.
Yes, my lord.
Yes.
And in case the reasons are not recorded,
Then
or
matter
release
goes.
him on bail. That is also provided in the proviso itself.
Yes, what is it?
My lord,
Shall be detained during the
provided that
period of
the court
investigation for more than half of the period of remand for the state offense under law.
for the said period or release him on bail
But
instead of
provided further,
personal bond.
no such person shall in any case be detained during the period of more than the maximum period of now this is for the maximum period.
My lord, the first proviso.
The first proviso say what?
First proviso says, my lord,
Hmm.
provided that the court may,
Hmm.
after hearing the public prosecutor and
Hmm.
for reasons to be recorded by it in writing, order the continued detention of such person for a longer period other than one half of the said period, or release him on bail instead of personal bond,
Yes.
with or without surety. So, my lord, even in and in the first paragraph, my lord, 436A main section, my lord, the language used is on his personal bond, and in proviso instead of personal bond. That is the notable difference. And according to my understanding, the moment if there is an objection filed by the public prosecutor, even then the court can
Grant him bail.
grant him bail. But in that case, my lord, the personal bond cannot be accepted. There has to be a surety. Which is why, my lord,
No, the
instead
court
of
can
personal
still,
bond-
if an objection is being
Yes.
filed, the court can still give you.
my lord,
But by recording reasons in writing, the court can further,
my lord.
instead of personal bond, direct you to be released on bail with or without released on release you not on personal bond, but with or without surety.
My lord, my grievance is solely on this ground also. my lord.
Hmm.
At page 230, my lord,
Hmm.
there is an order of remand that was passed by the trial court on 26/8
Hmm.
after I completed half term.
Hmm.
At page 230, my lord,
Hmm.
last line,
Hmm.
accused Rakesh Kumar Pal is remanded again till next date.
Hmm.
So, my lord, this is the first order of remand after completion of half term, and on this date, there was no order by the High Court dealing with 436A. This was an order passed under 309, my lord. And the mandate of 436A says if the trial court has to authorize the continued detention beyond the half term,
Has to record reason.
record reason.
So
And-
you are saying that beyond it,
Yes, my lord. My lord, the petitioner completed half term on 16/8, and he was eligible to entitled to be released on 17/8, 2022. And I have made a specific prayer to this effect, my lord, in my petition,
so is it your case
my lord.
that 436A applies without an application?
Yes, my lord. If the Supreme Court has held even an application is not required. It is for the court to see whether accused has completed the half term or not. The Supreme Court has held, my lord, even an application is not required. And the language used in 436A does not contemplate to of filing an any application, my lord. It is an exercise to be carried out by the court. This is an exercise only to be carried out by the court because Malak, this is a beneficial legislation. 436A is a beneficial legislation. What the Supreme Court has held. It is not my word, man.
And 437?
And my lord, even in page 231, the next order of remand, 99.
Wait, Mr. Counsel,
Well,
I'm new into this subject. Yes. What are judgments on that? Because you see, 438 says about an application.
Well.
439, the provisos to the 439 says about an application.
my lord.
Although 439, the main provision does not say about an application.
Yes, sir.
But the proviso says that an application has to be given to the public prosecutor.
Right.
But this aspect of the matter has not been mentioned in 436A.
My lord.
But what about 437?
When bail may be taken in case of non-bailable offence. When bail may be taken in case of non-bailable offence.
Understood. But does it say about the
Application.
application?
My lord, when bail may be taken, it means, my lord, according to me, there has to be an application. Because when bail may be taken in case of non-bailable offence, without an application, how can
So
bail be taken, my lord?
436A
My
is
lord.
not an application for bail.
Yes, my lord. Now, this is a provision under which we can apply, like 167(2), my lord. Under 167(2) also, my lord, there is no provision or no mention of the word that you will of the word application. Even though we file applications upon under 167(2) before the trial court upon completion of the maximum period specified under 167. And
No,
if
that is
there
also not an application for bail.
Application for
167(2) is
release, my
not
lord.
an application for bail.
My lord.
It is an application for the purpose that to bring it to the attention of the court that look here, I have completed this period, they have not submitted the charge.
But my lord, in
And as such, the
167(2),
court
my lord,
has to, cannot keep you in custody beyond that period.
my lord, my lord, it is also an intention that
We
I am
use the word
ready
default
to
bail.
furnish bail bond.
Huh?
167(2), my lord, is also a section which requires the person to submit a willingness that I am ready and willing to submit a bail bond. because this cannot be automatic. This is what Supreme Court has held. The operation of 167(2), there might be circumstances where accused can be felt threatened by some other outside elements, and he might not wish to be, enlarged on bail. Which is why, my lord, there has to be a specific application of the right. And if that right is not invoked, then that stage is gone
Prior to filing the charge.
prior to filing of the charge. So therefore, my lord, and the distinguishing feature, my lord, is that in 167(2), the person applying for release has to submit before the court that he is willing, and he is willing to submit bail bond or sureties as the court may plead.
Hmm.
Here, my lord, this is why, my lord, in 436A, with or without sureties has been used. Distinguishing features, 167 to 430. And my
But
lord,
what is
and the
this person,
judgment,
when somebody has to give a personal bond?
well, in case there is an objection,
No.
is subject to satisfaction, my lord.
No. A release under 436A
My lord.
is subject to furnishing a personal bond, maybe with or without surety.
My lord, is subject to the proviso, my lord. First,
No. Proviso comes something later
yes,
on.
my lord.
But in 436A itself, you
Yes,
have
my
to
lord.
submit a personal bond.
Yes, my lord.
He shall be released by the court on his personal bond.
Yes, my lord. On his personal bond.
So he has to give a bond
Yes, my lord.
that he undertakes to sue.
Yes, my lord.
So what is the difference with 167(2) then?
My lord, in 167 to a surety has to be given, my lord.
Here also with or without surety.
With or without surety.
So nowadays the Supreme Court says that in certain cases where a person has been languishing in the jail for more long years, or where a bail has been granted, also he cannot, he has to remove that surety,
Yes, my lord.
isn't it?
My lord.
Then
My lord. My lord, and even in considering 436A, Supreme Court has held that it is to be taken as a statutory bail akin to 167(2).
does it say so?
My lord. And my lord, my lord had asked for the judgments on 436A. I would like to place those judgments which are already there, my lord. The judgments on 436A, I have put a binder's clip on the judgments on 436A particular. Only that compilation could suffice. That binder's clip is there.
You have a very bad case.
My lord.
So many judgments you are giving.
No, my lord. On 436A only the judgments which are.
One judgment is so long. Tell me which is the best one.
My lord, Bhim Singh was considered in Satyendra Kumar until, so I am placing Satyendra Kumar until, my lord. At paragraph 46, my lord.
Yeah.
Para 46.
Yes. 45. 45 they have put it.
Yes, my lord. 45 the explanation section is there. Then 46, my lord. Section 436A of the code has been inserted by Act 25 of 2005.
See, I told you, I've not seen it in amendment.
My lord, one second. Before just if you got the permission, that what was the query that I was just listening? 436A, 437, 439, how it started. I think that your lordship wanted to know it. From where it started, originated. It was placed before Rajya Sabha, but that was not, it was cable, but they kept it. 2005, which your lord, that's why it was reading, it was very correlated. I have got certain, my lord, if your lordship pleases, my lord,
Let us read 46. Then we get a
because how it started from Supreme Court in 2013, there was a letter issued by the government of India. The jails are overcrowded, what to do? So 436A letter was sent. And the Chief Justice of India, he then Chief Justice of India, some cutting he got from some newspaper that was sent to the apex court. And on the basis of that, my lord, in human, there is a case in 2013, it was registered. Honorable Justice Lupur took up that case. And all the history was set out why 436A. This is what your lordship is, I think,
Mhm.
that was put in. So I will.
The
place it,
judgment
your
is
lordship,
already
let
there.
the Judgment be placed, I will ask. If your lordship give permission, I can place it.
Okay.
Yes.
Yes, read it.
46, my
46.
Section 436A of the code has been inserted by Act 25 of 2005. This provision has got a laudable object behind it, particularly from the point of view of granting bail. This provision draws the maximum period for which an under trial prisoner can be detained. This period has to be reckoned with the custody of the accused during the investigation, inquiry, and trial. We have already explained the word trial will have to be given an expanded meaning, particularly when an appeal or admission is pending. Thus, in a case where an appeal is pending for a longer time to bring it under 436A, the period of incarceration in all forms will have to be reckoned, and also for the revision. 47. Under this provision, when a person has undergone detention for a period extending to 1/2 of the maximum period of imprisonment specified for the offence, he shall be released by the court on his personal bond with or without surety. The word shall clearly denotes the mandatory compliance of this provision. We do feel that there is not even a need for a bail application in case of this nature, particularly when the reasons for delay are not attributable against the accused. We are also conscious of the fact that while taking a decision, the public prosecutor is to be heard, and the court, if it is of the view that there is a need for continued detention longer than 1/2 of the said period, has to do so. However, such an exercise of power is expected to be undertaken sparingly, being an exception to the general rule. Once again, we have to reiterate that bail is the rule and jail is an exception, coupled with the principle governing the presumption of innocence. We have no doubt in our mind that this provision is a substantive one, facilitating liberty, being the core intent of Article 21. The only caveat as furnished under the explanation being the delay in the proceedings caused on account of the accused to be excluded. This court in Bhim Singh versus Union of India 2015-13 SCC 605, while dealing with the aforesaid provision, has directed that rather than the Bhim Singh has been dealt with. The only caveat, what is mentioned in the judgment, my lord, the only caveat as furnished under the explanation being the delay in the proceedings caused on account of the accused to be excluded. Which is why, my lord, in the note, I have given a brief history of the case. The investigation took 3 years, 1 month. Charges were framed after 4 years, 2 months. And the prosecution took 13 months to furnish the documents under 207. So, my lord, the conduct of the prosecution
Now
on the
let's
basis
see
of fact
what
that
Bhim
delay
Singh
is not
says.
attributable to the petitioner.
Yes, Mr. Counsel. Let's see Bhim Singh.
My lord,
They're
having given our thoughtful consideration to the legislative policy engrafted in 436A and the large number of under trial prisoners housed in the prison, we are of the considered view that some orders deserve to be passed by us so that the under trial prisoners do not continue to be detained in prison beyond the maximum period provided under 436A. We accordingly direct the jurisdictional magistrate, chief judicial magistrate, session judge shall hold 1 sitting in a week in each jail/prison for 2 months commencing from 1/10/2014 for the purpose of effective implementation of section 436A of the Code of Criminal Procedure. In its sitting in jail, the above judicial officers shall identify the under trial prisoners who have completed half period of the maximum period or maximum period of imprisonment provided for the said offence under the law, and after complying with the procedure prescribed under 436A, pass an appropriate order in jail itself for release of such under trial prisoners who fulfill the requirement of section 436A for their release immediately. Such jurisdictional magistrate, chief judicial magistrate, session judge shall submit the report of each of such sittings to the Registrar General of the High Court, and at the end of 2 months, the Registrar General of each High Court shall submit the report to the Secretary General of this court without any delay. To facilitate compliance with the above order, we direct the jail superintendent of each jail/prison to provide all necessary facilities for holding the court sitting by the above judicial officers. A copy of this order shall be sent to the Registrar General of each High Court, who in turn will communicate the copy of the order to all session judges within his state for necessary compliance.
And now, Mr. Counsel, why are you bringing Madan Lal Chaudhary?
Yes, my lord. In Vijay Madanlal Chaudhary, my lord, the element of 436A was considered. And in paragraph 414, paragraph
Is
414, my lord.
this the PMLA
Yes, my lord,
judgment?
PMLA judgment.
Then
Paragraph 414, my lord. May I place it, my lord? Your lordship got it, my lord?
yes,
My lord, above paragraph 414, 436A has been quoted.
then
And my lord, in the statement of objects and reasons, it was stated thus: there had been instances where under trial prisoners were detained in jail for periods beyond the maximum period of imprisonment provided for the alleged offense. As remedial measure, section 436A has been inserted to provide that where an under trial prisoner other than the one accused of an offense for which death has been prescribed as one of the punishments has been under detention for a period extending to 1/2 of the maximum period of imprisonment provided for the alleged offense, he should be released on his personal bond with or without sureties. It has also been provided that in no case will an under trial prisoner be detained beyond the maximum period of imprisonment for which he can be
come
convicted
to
for the
416.
alleged offense.
Come to 416.
My lord. The Union of India also recognized the right of speedy trial and access to justice as fundamental right in their written submission, and thus submitted that in limited situation, right of bail can be granted in case of violation of Article 21 of the Constitution. Further, it is to be noted that the section 436A of the 1973 Code was inserted after the enactment of the 2002 Act. Thus, it would not be appropriate to deny the relief of 436A of the 1973 Code, which is a wholesome provision beneficial to a person accused under the 2002 Act. However, 436A of the 1973 Code does not provide an absolute right of bail as in case of default bail under 167 of the 1973 Code. For in fact situation of a case, the court may still deny the relief owing to ground such as where the trial was delayed at the instance of the accused himself. 417. Be that as it may, in our opinion, this provision is comparable with the statutory bail provision, or so to say, the default bail, to be granted in terms of section 167 of the 1973 Code, consequent to failure of the investigating agency to file the charge sheet within the statutory period, and in the context of the 2002 Act, complaint within the specified period after arrest of the person concerned. In the case of section 167 of 1973 Code, an indefeasible right is triggered in favor of the accused the moment the investigating agency commits default in filing the charge sheet or complaint within the statutory period. The provision in form of 436A of the 1973 Code has now come into being is in recognition of the constitutional right of the accused regarding speedy trial under Article 21 of the Constitution. For it is a sanguine hope of every accused who is in custody in particular that he or she should be tried expeditiously so as to uphold the tenets of speedy justice. If the trial cannot proceed even after the accused has undergone 1/2 of the maximum period of imprisonment provided by law, there is no reason to deny him his lesser relief of considering his prayer for release on bail or bond, as the case may be, with appropriate conditions, including to secure his her presence during trial. Well, the last line, pausing for a moment, my lord.
Read 419.
My lord. Section 436A of the 1973 Code is a wholesome beneficial provision which is for effectuating the right of speedy trial guaranteed by Article 21 of the Constitution, and which merely specifies the outer limits within which the trial is expected to be concluded, failing which the accused ought not to be detained further. Indeed, 436A of the 1973 Code also contemplates that the relief under the provision cannot be granted mechanically. It is still within the discretion of the court, unlike default bail under 167 of the 1973 Code. Under Section 436A of the 1973 Code, however, the court is required to consider the relief on case-to-case basis, as the proviso therein itself recognizes that in a given case, the detention can be continued by the court even longer than half term of the period, for which reasons are to be recorded in writing, and also by imposing such terms and conditions so as to ensure that after release, the accused makes himself or herself available for expeditious completion of the trial. So the recording of the reason has to be there. May I please 420, my lord?
Read.
However, that does not mean that the principle enunciated by this court in Supreme Court Legal Aid Committee representing under trial prisoners to eliminate the agony and pain of persons kept in jail for unreasonably long time, even without trial, can be withheld down on such spacious plea of the state. If the Parliament legislature provides for stringent provision of no bail unless the stringent conditions are fulfilled, it is the bounden duty of the state to ensure that such trials get precedence and are concluded within a reasonable time, at least before the accused undergoes detention for a period extending up to
Yes, why are you bringing Hussein and another?
My lord.
Hussein and another, why you are bringing that?
My lord. In Hussein and another, my lord, this is 2017, my lord, para 28 to 30.
Para
28 to 30.
28.
Yes. Please it, ma'am. And 29.1.4, my lord, of Hussein. 29.1.4.
And which paragraph you said?
28, my lord.
28. And what is inhuman condition? That is the case.
Well,
Mr.
for a
Das
moment, my
was
lord,
referring.
paragraph 29.1.4, my lord.
I read it. What is inhuman condition?
My lord. At para 54 to 56, too, my lord.
54.
Paragraph 54.
And what is the division bench judgment in this one?
My lord.
29/9/2022.
My lord, it is there is no marking of the paragraph, my lord. But my lord, Satyendra Kumar Antil and Sudan Singh was considered. My lord, in this case, accused was booked under section 20 of UAPA, and his appeal was pending. In the meantime, my lord, half term was completed, pending appeal, and the IA was filed, my lord. And at page 5, my lord, second para of the judgment.
So your submission which you have made, it has to be before that court only.
My lord,
It has to be before that court only, it doesn't hold water. You say court means the trial court, not the high court.
my lord, I am on to the order of remand after they completed half term. In
But
case of
this is,
Hussain, my lord,
but this
it is the
respect to the
duty of the
matter has
trial
been
court.
given in the appeal. This order has been given in appeal.
Yes, my lord.
In this,
Which order, my lord?
this one, Justice Shyam's order.
Yes, my lord.
Anything else? But tell me one thing. In one judgment, it has been said that you don't need to file an application, even if the circumstances persist. If you don't need to file a bail application and the court on its own accord has to do it, is it your submission that non-recording of the submit reasons thereupon violates the mandate of Article 20?
Exactly. On 26(8), that exercise ought to have been carried out by the trial court, because it would defeat the object of 436(a). Otherwise,
Now thereafter, you filed an application
my lord,
which have been rejected.
Right.
Now what happens to that period?
my lord,
What happens to your that period?
that period becomes
Regularized?
illegal detention, my lord.
Understood. Only that, but thereafter, now the court has recorded reasons.
My lord. But
Once
it
you
is
file
void
that
ab initio, my
application-
lord. My detention is void ab initio. Even after filing of the charge sheet, my lord, like in 167(2), even after filing of the charge sheet, my right to default bail remains. Therefore, my lord, even if there is a reason recorded in writing after a certain period, and in non-compliance of 436(a), my detention still remains illegal, because this provision cannot be diluted, my lord. The word shall clearly mandates the intention of the legislature. So tomorrow, my lord, this trial court can deal with such a situation in similar cases, my lord. There is no need to record reason. Every under trial prisoner will be remanded to judicial custody without recording any reason. And the moment after 1 or 2 years, the under trial prisoner comes before the court will record reason and further authorize the detention. So this will be a dangerous precedent when practice, my lord. And in fact, my lord, in my humble submission, my lord, this is the practice that has been going on in large number of cases. The courts are not aware, because, my lord, normally what happens is the remand orders are passed very mechanically, without any application of mind. Whether he has completed half term or not, it is not necessary to reckon. This is the practice that is going on in the lower court at large, my lord.
Let us again see 436 with 436A. When does the public prosecutor gets the opportunity of the objecting? Does he get the opportunity? Is it automatic? Or does he have to file, which is necessary in terms with 167? Two.
My lord.
In NDPS cases,
Yes, my lord.
he has to file an objection.
He has to file it.
He has an opportunity.
Yes, my lord.
Now, this objection, does it come immediately in that it has to be filed prior to the completion of 180 days?
No, my lord. The moment he is entitled to be released under 436(a), before passing the release order, the public prosecutor has to be heard.
Counsel, you are not on this.
My lord.
As per section 37, if I'm not,
Yes, my lord. 37.
37 read with 167 too. The public prosecutor in the NDPS case can file an objection
Yes, ma'am.
that this period of 180 days has to be enlarged to 365.
Right.
When does he get the time? File?
At the time of filing the application, my lord.
When? When does he have to file?
The moment the accused files for files a bail application, ma'am.
So the moment he asks for a default bill, he has to file? Or
Yes,
he
my lord.
can file it prior to 180 days? That further period is required.
After completion, my lord. After
Or
completion
because
of
here,
180 days.
why I'm saying this, there's a reason why. In this case, the public prosecutor would be aware, in this case,
Right.
that look here, this is a period is 10 years. He has already completed 5 years or half of it. So under such circumstances, the public prosecutor there is no opportunity of filing an objection unlike that which have been given there.
Right.
When does the public prosecutor get the chance? Means the court has to give him an opportunity. When?
Well,
Or
at
is
the
it
time of
because what you are
considering
saying
whether he
is
will be
on
remanded at the time of
28
passing of the order of remand.
No, on 28/6/2022, you are saying
Right.
the remand which was being made without passing a reason
Right.
or giving a reason for continuation out there is on the face of it bad.
Right.
You are saying that. But what is the time when the public prosecutor gets the chance or is being asked to object? Because how do you apply the proviso? The proviso would never come. Otherwise, if
Well,
we just use the word shall, without this, the first proviso would never come. But the moment the person completes 5 years, in this
shall be
case,
released on.
he has to be released. Then when does the public prosecutor get the chance to object? If we are considering it as automatic. That is a very vital question because you are saying that it becomes detention. Just in a particular case, a person who have been granted the bail
My lord.
and he have not been, the authority concerned is not accepting that, would amount to a illegal detention. Can you say this to be illegal detention without giving an opportunity to or asking the public prosecutor out there, do you want to object? If we say just that it is an automatic thing, very well, then why do you need to hear the public prosecutor? Tell me.
My lord, in the event the court decides upon the issue.
We'll hear
whether-
you at 2.
Well,
after hearing that it means the Advocate General come. Because that question of the first proviso apply. That aspect you need to clarify. I hope, Mr. Das, you're getting it. That aspect, the triggering of the public prosecutor right to file objection, because he has a right to object when it will come.
So when what I feel that the remand of his completion was on 16/8/2022.
Hmm.
16/8/2022, that the half term that was completed on 16/8/2022. So when the records were before the learned trial court, that is my what I am thinking. Lordship has put to it. On the day when it was put before the court, that means he completed 1.5 term. Now the accused is being produced. Accused is always produced. Now on that day, the court should have asked that whether you have got objection or not. My submission will.
Now, if the court is oblivious of the fact, or maybe a case the court may have forgotten and have done it, and you have not pointed out, or the public prosecutor. Now, when does the public prosecutor get the right to object? Because you see, that is why I'm saying, asking you this, look to the NDPS also to that effect, as to there is a chance or there's an opportunity being given to the prior to the completion of 180 days. But when is he going to object here? We'll hear you.
Right.
much of.
Then I'm not entitled. But no, then I write good. Automatic. This is what code is hell. No, এখানে তো এইটো দেখালো। এটাতে তো কিছু এটা আনা নাই, তো 157 মই কিয় কৈ আছো? পৰতে দেখা। Why they provide the why they provide? The provider is given just to see whether
A and 167.
Right.
Look out here at paragraph number 419.
Lordship.
We got it?
Why that? 419.
Yes, read it.
Section 436A of the 1973 Code is a wholesome beneficial provision, which is for effectuating the right of the speedy trial guaranteed by Article 21 of the Constitution, and which merely specifies the outer limit within which the trial is expected to conclude, failing which the accused ought not to be detained further. Indeed, Section 436A of so and so also contemplates that the relief under the provisions cannot be granted mechanically. It is still within the discretion of the court.
Indeed, 436A of the year also contemplates that the relief under this provision cannot be granted mechanically,
My lord.
which means it is not automatic.
Yes. It's
You
not
see, the
automatic.
question of there being a what do you call the illegal detention shall not arise automatic.
My lord.
Then you see,
It is still within the discretion of the court. Unlike the default bail under Section 167 of 1974, under Section 436A of 1973 Code, however, the court is required to consider the relief on case-to-case basis, as the continued by the court even longer than one half of the period for which reasons are to be recorded by it in writing, and also by imposing such term and condition so as to ensure that after release the accused make himself herself available expeditious completion of. It's true, man.
then kindly see 421.
In our opinion, therefore, the Section 436A needs to be construed as a statutory bail provisions and akin to Section 167 of 1973 Code. Notably, learned Solicitor General has fairly accepted during the argument and also restated in the written notes that the mandate of 167 of 1973 Code would apply with the full force offense, full force even to cases falling under Section 3 of the 2002 Act regarding money laundering offense. On the same logic, we must hold section 436A of 1973 code could be invoked by the accused arrested for an offense punishable under the 2002 Act being a statutory.
And 418 also,
My lord,
there was this specific argument being made by the solicitor.
my lord. The Lord Solicitor General was at pain to pursue it as that this view would impact the objective of 2002 Act and is in the nature of superimpositions of section 436A of the 1973 code over section 45 of the 2002 Act. He has also expressed the concern that the same logic may be invoked in respect of the other serious offenses, includes the terrorist offense, which would be counterproductive. So be it, we are not impressed by the submissions, for it is the constitutional obligations of the state to ensure that the trial are concluded expeditiously and at least within a reasonable time where the strict bail provisions apply. Now come, my lord, if a person is detained for a period extending up to the 1.5 of the maximum period of the imprisonment specified by law and is still facing trial, it is nothing short to failure of the state is upholding the constitutional right of the citizens, including the person accused of the offense. Now, in the instant case, what happened, my lord? 45 witnesses have already been examined, and 3, 4, 5, my lord, the witness has been left out. So, my lord, is now concluded, and the our High Court, my lord, already directed to day-to-day trial, and it is completed within 6 months. And it is going on, my lord. The Honorable High Court orders has been complied with by the Land Trial Court. Day-to-day proceeding is going on, my lord. 45 witnesses has been examined. Minimum, my lord, maximum, my lord, 6 witnesses has been left out. Now, so, my lord, at this stage, my lord, the granting of bail.
But Mr. P,
My
the
lord,
question is it the question that the person there might be a tempering of witness is a consideration in a 436A, or is it the question of delay in the trial?
regarding delay in the trial, my lord, already High Court has directed to complete the conclusion.
That is a different thing. The
Yes.
High Court has directed them to conclude within 6 months or 5 months or whatever. Maybe. That is another aspect of the we are not concerned to
Yes,
that.
regarding tempering, my
But 436A
lord,
is on the question of if there is the objective behind this, that there has to be an expeditious trial
my lord, yes.
for which a
yes.
person who is only an accused cannot be permitted to remain in custody
Yes.
beyond the period after completing 1/2 of the total. Thereafter, you put him whatever maybe, that is a different aspect. But this is the basic idea behind
My lord.
having it. If that be so, then in that case, did the ordinate bench look into that aspect of the matter? Or even the trial court look into that?
And now, my lord, the remaining the 6, 7 witnesses, whatever it may be left, there may be possibility, my lord, tempering of India. That's why, my lord, the trial court, after perusing of the materials, after going through the event, High Court also, my lord, after perusing the materials, rejected this, my lord, 436A.
Trial court did not go into any other question. Trial court said that the High Court have said, so that is why I'm bound by what the High Court says.
My lord, yes, correct. But, my lord, here I prepare a note, my lord. Now, this court, my lord, have to, my lord, satisfy why, my lord, he has not been released on bail under 436A. Then, my lord, you'll also go into the merit of the case, my lord, and see that, my lord, his conduct. That is, my lord, the record I have seen, my lord, the entire record has not come. Only the orders has come before this honorable court.
What is the conduct?
Conduct, my lord, he is threatening. He threatened, my lord, many persons, and his co-accused also threatened if he disclose anything before the, and he is dangerous. So, my lord, that's why, my lord, I prepare a note regarding, my lord, the 436A.
The judgment which my learned friend cited, kindly see 418 of that same judgment your lordship is reading. 418.
I've just read it.
Yes, 418.
I've seen it.
Yes, I have.
That was 419, my lord. 418.
418 also is read it.
Yes, 419 also we have it.
Is read it. Yes, what is this?
This is, my lord, the why his custodial detention is necessary, my lord. Though there is a, my lord, provision of 436A.
Then why is it necessary?
Yes, that is, we start from here, my lord. Your lordship may come to the first page, my lord.
Hmm.
The first study, my lord, the section 4 provides that this is a provision. I'm not going to read. It's come from, my lord, paragraph 4, my lord.
Hmm.
From reading of the above provisions contained in 436A CRPC, it is found that though the legislature used the word shall in the said provisions, but from the harmonious constructions of the said provisions indicates that the provision is not mandatory but directory only.
Who
It
says?
is now, my lord, I am preparing
Oh,
this. My
you
lord,
are
no,
saying.
yes, that's why, my lord, to, my lord, they interpret the sections, my lord.
Can't help it. When the Supreme Court says it to be
My lord, yes, mandatory, but
then
the
how
first
can I help
proviso, my lord, which have given the, my lord, the discretion upon the court. That is why I'm saying, my lord, it is not, my lord, fully mandatory. Yes, I'm the next, my lord, continue, my lord, your lordship may see the why its detention is necessary. It is forfeited from the first proviso, the section 436 is CRPC, which provided that the court may, after hearing public prosecutor and for the reasons to be recorded by in writing, order to continue detention of such persons for a period longer than a half of the said period. Thus, discretion is based upon the court to decide whether the accused can be released, even if undergoing detention exceeding up to one half of the maximum period of the imprisonment. And in next page, my lord.
Now,
For-
who are the witnesses to be examined?
My lord, now
You are
the
saying 6 witnesses to be examined. Who
my
are
lord,
the six?
at this stage for me, my lord, difficult to, my lord, the
Well?
my lord, I have taken the, my lord, the from the
No, then how can you say that? If
but
the
that
witness
instruction I
is
have not been received.
concerned, if they are official witnesses, then
No, I have, my lord, the communicate with the special PP. They said, my lord, there are some vital witnesses will left out. So at
vital
this-
witnesses doesn't help you. But he has to come up. You are objecting.
My lord,
If you are objecting, you have to come up with data, facts and figures.
yes, but that's why, my lord, and then I need some time, my lord, one day time to collect what the vital witness.
Okay, tell me tomorrow,
My
2
lord,
o'clock.
my lord.
Well, that your lordship was putting a query. We were during the decision time, we said that the anxiety of the court was about regarding that it is not possible. The court, it is not possible. There are so many accused, there are so many cases. So how the court will come to know that one or half term is completed? That will, with great respect, my lord, that is 309 of the CRPC, the court comes to know. Kindly see 309, my lord. Every after 15 days, an accused has to be produced before the court for remand under 309. 309, my lord, 2 kindly be seen, my lord. 3092. If the court, the court, after taking cognizance of offense or commencement of the trial, finds it necessary advisable to postpone the commencement or adjournment any inquiry trial, it may from time to time, for reasons to be recorded, postpone or adjourn the same on such terms as it thinks fit for such time as it considers reasonable, and may by warrant remand the accused if in provided no magistrate shall remand an accused person to custody under this section for a term exceeding 15 days at time. So when an accused is being produced, my lord, every after 15 days for remand, my lord, there has to be a record of reason. So once the record is before the court, he will look into then 436A. So it is not possible. Humanly is not possible. There are so many cases. But when the record is there before the court, then he looks into 436A.
But how will he keep on noting everywhere?
No, there is
That
no,
yes, last time it was 430 days, today is
no, my lord.
so and
He
so.
will, no, he will look into the record. Record will clearly reveal on
No,
16.
but Mr. Das, there are 3 periods. One is a period for investigation, one is a period for inquiry, one is a period for trial.
Right.
Yes, investigation, how much period you'll have to keep on note every time. Or if you say that yes, it is the requirement in view of the judgment in 2015, where there was a specific direction being given that they are to look in everything as to take a decision for 2 years, they were directed to look into those aspects. So something similar is required to be done.
But these are, my lord, there is a direction to look into this particular case, my lord. It was initially, your lordship, I have seen the record, not only for day-to-day trial. Day-to-day trial, there was earlier also. but it was not complied. Thereafter, 2021 is a very serious matter. It has to be looked, and the learned trial court is looking after. So, with great respect, learned trial court is also aware of it. On 16/8/2022, when the one half term is completed, thereafter, when the accused was produced before the court, my lord, for remand, definitely he was aware of it. So my
No,
interpretation.
why should we go into that question now? Taking into consideration, which tomorrow he may say something else, taking into account which are the witnesses, 6 witnesses, he says so. But overall, 436A, prima facie for this court, is a beneficial legislation done for the purpose of taking care of that a person who is accused of a crime should not be inside or detained for a period more than 1/2 of the period.
Correct.
And the reason is Article 21,
Correct.
which is the question.
Yeah.
Now, if you see many other judgments, even the case of this person concerned, which matter went to the Supreme Court in 167,
Yes, sir.
there also the Supreme Court dealt with the aspect as regards the right of a particular person for default bail. And more particularly in that case, there was no mention, there was no application for default bail. Because if you see 167, which is required that he has to apply for the purpose of saying that I am willing to furnish bail. That is required, which is not akin to out here to 436A. But then also the Supreme Court says that as it is a matter of liberty, we can't be taking along on that aspect. And under such circumstances, say that there was a submission being made
Correct.
in the court. And because of that, we can take it that this aspect of the matter was before the single judge of the High Court.
167, when it
Yeah,
is certified.
yeah.
But here there are two things which your lordship has pointed out. 436A, first part is tell and second part is meet. Second part is meet. So a situation may arise before the court that yes, on the first part, mandatory he has to be released on bail. But it is now on the court. The court. It may so happen there may be an objection from the public prosecutor. That doesn't mean an objection of public prosecutor that he will not be entitled to be released.
No.
This is what I understood. If there's not, it is
The proviso only says
Yes.
that the public prosecutor will have a right to the objecting. And when it is objected, the court may, for reasons to be recorded in writing, shall mention out there
Yes.
that he needs to be further detained, or
Yes.
he may be released on
Yes.
not on personal bond, but on basis of some securities.
Correct. Right.
That aspect I understood. Although I am a suspension judge, well, let the matter be taken up at 2. Tomorrow I'll pass the order in the court. It's a case of personal liability.
Ma, there are few, I don't know whether the judgment of how it initiated 436A, how it came to Supreme Court, how it was dealt. That if your lordship wants, I can give a note of it.
If this court has to deal with that, then the 6 witnesses may finish off. Yes, Mr. Advocate General. Hard to find you.
There's a special bench at 2 o'clock.
No, what has happened, you see. This is a matter of dark number 97. I called you, there is a specific purpose for it. Dark number 97. These persons do not have a leave or a written permission from the Deputy Commissioner to reside. So under such circumstances, under 18, the Deputy Commissioner has the power to evict. But what is happening is, in spite of the state government taking up a particular decision that this particular land will be used for the second medical, or even for the purpose of TB hospital, the revenue authority is still deciding on some aspect and saying that permission has to be granted, the settlement has to be given and all this. If that is happening, Isn't it a serious matter? Then why should this court? Because there is already a direction by Justice Burwa in one of the matters. In this case, more particularly, writ petition 292, wherein they had earlier approach and the single coordinate bench had directed that let their case be considered for the purpose of allotment, and till then a status quo has been. Now, in the meantime, you have again taken up another decision on 10/11/2022, whereby notices have been issued against them, and there has been writ petitions filed where there are stay orders to them. So you have got stay. Wait, stay. Now, while everything is going on, still the government or the revenue department of yours is contemplating of granting allotment. Now, if this court has to, Mr. Dhar is not against the idea that yes, they are going to leave it for 6 months, after 6 months. But if they leave it and thereafter you again keep on allotting some other people, then should this court do it? In dismissing it rather than wait for your petition on your allotment, it may take years. And I therefore ask for you for an undertaking that this land, under no circumstance, should be allotted to any individual. It will be used for second medical college or TB hospital for public purpose. If that is being used on that undertaking, I can record that undertaking, and on the basis.
Instead of my undertaking, Lordship, let there be a affidavit coming from the highest authority of the revenue department before this honorable court. Lordship may give us 10 days time. That affidavit will be filed. Let that affidavit be on record for all times to come.
That is the two options. Either an undertaking by the Advocate General would
That
have
is perfect.
sufficed.
But sometimes this order may get disappear. So therefore, that affidavit should be there. It should be in the record also of the government department.
No, if you see one of the files, just
I have seen, Lordship, that some
Mr. Kindly show the affidavit which have been filed by them, the last document. That is at page
it is a
82.
deputy commissioner.
You see this what has happened.
Yes, I have seen it, Lordship.
Now,
That Firoza Begum,
this is now
very
what is
recent,
going to happen.
17/3/2022, right, Lordship?
Now what is happening is, in view of a decision being taken in writ petition 292, where there is a direction to consider, and on the basis of that, they are taking that, help of that. Although there is a decision of the state government in another meeting that we want to keep this particular land only or earmark it for the second medical college. Now, what is going to happen otherwise? That is why I requested you or some affidavit would do by highest authority. The reason why I'm doing it, that this, in that view of the matter, this further consideration in terms with the order passed in WPC number 292 should not under any circumstances, in view of your specific decision to hold the second medical college there,
Yes, Lord.
should not.
I fully endorse Lordship view. So we have to protect that land. And in case it is given also, if it is required for the hospital, then it has to be acquired now. Is Firoza Begum.
No, it has not been given till now.
Oh, it is,
But
it is not, it is under process.
It is in the process. No, 3 persons have already been given,
Yes, this is what he has told me, Lordship. I
of
have
which
got it.
one of the premiums you have taken after doing all these things.
That is what certain, somewhere something is little bit dicey. So we'll find it out. Lordship.
And do you know the most interesting thing is, you have given that person 1 kata 10 letters of that precious land at 2,45,000 or 3 lakhs. And you are going to acquire most probably in lakhs.
So I'll find it out. Let 10 days or 2 weeks may be given. So I find out and I'll find out what exactly is happening.
Mr. Advocate General, let us finish up this matter within this year, financial year. I was supposed to,
Yes, yes.
with your undertaking, I was supposed
Now I
to
can give the
today.
undertaking. That undertaking may get disappeared.
No, I'll record your
The
undertaking.
Lordship
here.
order, I have seen lots, certain things, certain records get disappears in these kind of things. So let us be very, because when if it comes from the government Lordship, then it will be in the government secretariat's record.
Let it have it. let us have it on 30th of March.
Yes, Lordship, 2 days before also notification.
Okay, let us have it on 28th of March.
28.
I'll dispose of on the
Yes,
basis
yes,
of that.
Lordship. I'll get the affidavit.
Because this has to be clear.
Yes, yes.
Heard Mr. Adhar, the learned counsel appearing on behalf of the petitioner. And Mr. Mr. the learned advocate general, Assam. Mr. D. Nath, the senior government advocate. The learned advocate general has submitted that he requires he requires a
days.
week's time for the purpose of filing an affidavit by the highest authority of the revenue department, giving an undertaking as regards the use of the land in respect of Dag number 97. Taking into account the same, let this matter be again listed on 28th of March 2023 for final adjudication.
Highly obliged.
I don't hear you. We still have a glass of.
My lord, to include the DAG number 96 also, along with DAG number 97.
96 is also another
Yes.
thing. This is 97. 96 is nearby.
That is also for the hospital.
Government land.
Then the Lordship may include both.
96 and 97.
Highly obliged.
Lordship, may I please, Lordship, in item number 32, we are holding position deck number 201 and 202.
Of what land? Where is that land?
Okay, TB hospital notices of
201 and 202.
202 also.
And you? You also want to say some other dark? Same. 201 and 202.
All.
एक मिनट वीडियो के It's ini boleh itu ya Pak. Itu Pak. Yes, the bench has fallen. Yes, Mr. Muzumdar, your matter.
At number 7 to 12.
Itu na?
May I pray for some accommodation to your Lord?
You are appearing for?
I'm appearing for respondent number 13 in this matter. Petition Lordship. I'm also the applicant in the IAC bill.
Oh, you're Mr. J. Roy Jr.
Lordship, I thought Mr. Sandeep Patel. I appear on behalf of Mr. K.N. Chaudhary, senior advocate, Lordship.
K.N. Chaudhary.
Yeah.
Which matter? What is this matter about? Isn't that the matter? That matter?
Reservation.
Well, reservation, in fact, I should inform the Honorable Court. 2-3 writ appeals are there. One writ appeal by the general category candidates against the judgment passed by Honorable Justice A.T. Chaudhary. Other appeal by the reserve category people, and then some other matters. Now there was a submission that the matter to be taken up, and then also a submission that the Honorable Chief Justice said that all the matters, even single bench matters, will be taken up by the court number 1 now. So there was a submission made on behalf of Mr. K.N. Chaudhary, my friend, that then in that case, if the petitions are also taken up by the Honorable Court, then we'll be losing one forum. Somehow this Honorable Court was not agreeable, and that ultimately it was directed that all the matters be taken. So
By?
today,
By the single judge?
now by the division bench, court number 1. So those matters were listed today, but in one matter, since there was not service was not complete, the matter is section 28. This is the position. Yep.
So, means whatever will happen will the fallout of these,
I know.
the fallout of the division bench will have an impact.
Positive.
Because 18-1 has been challenged now in the division.
It has gone there because
Because if I see
Right.
on the last occasion, Mr. Das had made a submission that there was a writ appeal as a writ petition file.
even the writ petition challenging 81 also will be taken up by division bench now.
Should we not place this matter also before a petition?
Not me. Lord, what has happened when the writ appeal was being taken up by the division bench? Lord, the issue arose that pursuant to this, an OM has emanated from the judgment of Bhagwan Patel. The lordships called upon those matters wherein 18-1 has been challenged. Lord, before your lordship, Lord, the issue is pre-Bhagwan Patel state, wherein the judgment was rendered. Lord, those issues are still not as if Lord, that the Bhagwan Patel either implementation would be allowed. And pursuant to this, Lord, as per your lordship's order, those writ petitioners which are before your lordship, those have now challenged that by filing a new fresh writ petition challenging to 18-1. My lord may take it from that. That is okay.
No, 18-1 has not been stayed.
No, my lord, not been seen. The only thing that
Single bench or the coordinate bench have categorically observed that any promotion or anything done shall
will
be
be
subject to the
subject.
outcome of the writ.
That correct.
Now, these matters will have, although this whatever may be, the 18-1 may not affect the adjudication of 18-1 may not affect, but the writ appeal would be, the adjudication in the writ appeal have an impact on
Lord, if I must correct, what has happened? Lord, those matters wherein Bhagwan Patel judgment was delivered, Lord, these matters were also a part of those petitions.
these matters. Well,
Yes, my lord. Pursuant to this, my lord, the Bhagwan Patel judgment came in, and we came to this court that the Bhagwan Patel clinches those issues which are involved in this writ petition. There was a submission on the counterpart that, my lord, if the other's coordinate bench differs, it might be referred to another bench, might be a larger bench. So, my lord, again, these matters were heard before Justice Elizabeth, Honorable Justice.
that I know on
My lord,
29/11/2022.
and we were awaiting the judgment. Meanwhile, this
These are
18-1 OM came in, and the other party, the respondents herein, they filed an IA stating that now this 18-1 we implement. So, my lord, now there is a difference. Either 18-1 would be implemented or the Bhagwan Patel's death. But that is because we are pressing that 18-1, our judgment of Bhagwan Patel clinches those issues which the earlier writ petition. We were the writ petition. The issue has been dealt in Bhagwan Patel. Bhagwan Patel explicitly makes it clear that competency does not lie with the state to debar a meritorious death. That was the stand of the state government. Then, my lord, 18-1 comes. 18-1, they bring in that no, again the memorandum impugn clause again has been
Mr.
brought in.
Counsel, what do you want? Tell me. Let us not make it very complicated.
I will lead to my lord.
If you want not to do, don't do. I have no problem. I have no problem whether you want to do it or not. If you don't want to do it, don't. I'll be happy.
Well, if my lord takes it after some time, can
Why?
it be with the presence of my senior member? It be better to
Why?
assist my lord on this issue.
He doesn't have a senior.
Can I wait for my lord to take it?
We adjourn this sign at that.
Lord?
We adjourn this sign at that till the disposal of the retreat. I think that is, you see, whatever may be, you are claiming your relief here on the basis of
Bhagwan Patel.
Bhagwan Patel is put to challenge in the
Writ appeal.
although there is no stay to that. Obviously, there cannot be a stay.
That cannot be correct.
In fact, what has happened was that in Bhagwan Patel, they have only decided 2 writ petitions.
Yes, my lord,
Remaining
equality forum,
66
basic.
remain. So under such circumstances, I hope the division bench now decides that Bhagwan Patel. And then with that, we will follow up.
If I may, Your Lordship.
So we adjourn this matter.
Lordship, could I please be granted 5 minutes time, Lordship? I'll consult
You
my
want to
senior
go to the
regarding
5
this,
judges bench?
5 minutes time, Lordship. I'll consult my senior regarding this particular issue, Lordship, that should this matter be tagged along with the
Mr. Counsel,
other matter lordship.
kindly don't make that submission
Lord.
before this.
Apologies,
You instruct the counsel or the senior instruct?
lordship.
Who instruct?
Lordship, I'll just take instruction.
The senior instruct.
No lordship, not the client, your lord.
Then your name should be sent to the full court.
No lord.
Lord, may
Apologies.
take it up tomorrow with senior counsel of both the sides and possibly he's
No,
senior.
not tomorrow. Why should I take it up tomorrow? Let the matter be listed or let it go before the division bench if you want it. I'll place it before the division bench as the matter is pending out there. This is the outcome of the Bhagwan Patar. So let the division bench take a call.
Lord, in that regard, my suggestion is that, my Lord, this 18-1 issues are separately dealt by these writ petitioners, Lord, in a separate writ petition. And before my Lord, the issue is pre-Bhagwan Patar stage. So, my Lord, your Lordship can always take a decision in that respect that whether 18-1 pre-Bhagwan Patar can be implemented. But in my respectful submission, your Lordship can do it. And those writ petitions are separately, it's not a part of this tagged up matter.
At the request of the learned counsels for the parties, let the matter be listed up.
Hello,